Good evening. It's Wednesday, November 9th, and this meeting of the City of Gaithersburg Board of Appeals is now called to order. Welcome. It's great to have a bit of a crowd, which isn't our usual attendance, so glad to have everybody here, and thank you for joining us. There are 3 members present. We have a couple who are not able to be here, so Phil Cook, who is an alternate, will be participating as a board member in full standing. We have 3 items scheduled for our agenda tonight. First is a review and approval of minutes from our previous meeting. Next is a public hearing for a special exception, and then the third is a petition for administrative review. We'll begin with the minutes from our September meeting. Is there any discussion or motion regarding minutes?
I move to accept the minutes from the September 14th, 2022 meeting.
Second.
All those in favor?
Aye.
Aye.
Motion passes 3-0. There's a minor typo in your title. Double N at the end of the name.
Thank you.
You can always count on me to find those. Great. So moving on to our second item, which is the special exception, a public hearing on case BOA-9410, 2022, which is a special exception for a private educational institution at 205 South Summit Avenue. Jasmine, are you going to introduce the case for us, please?
Good evening. This is a public hearing on Board of Appeals case BOA-9410-2022. The hearing was published in accordance with the requirements of the city charter and code on the city's website, and the property was properly posted. At the present time, there are 26 exhibits in the record files, and they're referenced in the exhibit list in the files. The individual exhibits may be reviewed during the course of the meeting or in the Planning and Code Administrative Office during regular hours at City Hall or on the city's website. Any objections to the receipt of any exhibit should be noted prior to the closing of the record, otherwise they will be deemed received in evidence. As shown on the screen, the property is located at 205 South Summit Avenue and is zoned RA. So the applicant is requesting approval of a special exception for a name change and a student increase from 55 to 77 children for a private education facility with a daycare. Pursuant to section 24-25, subsection 7 of the zoning ordinance, private institutions require special exception. On August 9th, so just a little brief history, on August 9th, 1990, the Board of Appeals granted special exception application A-397 for a YMCA accommodating 39 children. That special exception was later amended as special exception A-397A on July 8th, 1993 for a private education institution named Montgomery Primary Achievement Center with before and after daycare for 55 children ages 2 and 3. The applicant went before the Planning Commission on November 2nd for recommendation, and the Planning Commission recommended approval for this application. And I will have Eileen Coyne from Sandy Ridge Academy, who's going to do the presentation this evening.
Great. Thank you.
Thank you, Jasmine.
Thank you, Eileen.
Thank you very much.
And before you begin, we need to swear you in.
Oh, okay.
So if you raise your hand. Do you solemnly swear and affirm under the penalties of perjury that the testimony you are about to give in this matter shall be the truth and nothing but the truth?
Yes.
Thank you.
Thank you very much. I will keep it brief, and then if you have questions afterwards, I can be more thorough. We, as Jasmine had said, we're requesting an increase of 77 students. We currently only have 31 students, but because the Maryland State Department of Education has approved us for the space that we use, we would like to always be prepared if our population grows to meet approval of the city as well, the city of Gaithersburg, as required. We had an additional classroom given to us in 2020, right around the pandemic, and that allowed us to increase our numbers up to 77. And Jasmine has pictures of just the floor plan. It shows that we have 5 classrooms and office space, and use of the church's assembly undercroft area that we use for indoor and indoor activities in inclement weather, as well as rest area. Our operating hours are from 7:30 to 6. But we have children coming in at staggered times. It is a nursery school with the before and after care component. In the summer, it's all the child care component. So our school calendar is from September to June. And then we do run about a 7-week summer program between July and August. And that's when we might have children with broader ages up to age 12 and as young as 18 months. So our families are offered times of 9 to 1 or 9 to 3 for the school portion. And then the families that need a longer day because of work or other choices, they can access the program starting at 7:30 in the morning. So let me just see, I'm supposed to look up, but I feel like I'm going to flip over in the chair. So those are the classroom spaces. They're really, they're accessible. We follow all the fire code requirements, everything that is meeting standards for safety and well-being of the children. We also have currently 10 staff, who is exactly what you would need for the number of children that we do have, but we also built in for 12 parking spaces when we go to talk about that, just to make sure acts as a buffer, because sometimes children need more support than just the standard ratio that's required. The Gaithersburg High School hours would not conflict ever with our children because their bell time is 7:45 and 2:30, so we planned it around that way. We do have families sometimes coming as early at 7:30, but most of our families come between 8 and 8:45, the before and care. They just want that buffer to be able to get their kids in before they go to work. So we've never really had a conflict with that. And just the way the road is set up, it's really only used by the church and us and Gaithersburg High School, because it just comes into the back of the high school. It's a dead end. I don't know if the word's dead end. It's not dead end, is it? But it eases into the back of the Gaithersburg High School campus. So it's really a low usage street. So currently, because we have 31 students, and even when we've had 50, we had 52 students just before the pandemic, we were always able just to use the lower space. The church has given us 13, that's shown in the color diagram, 13 spaces in the lower level. 2 will be set aside for staff, and the others can be accessed for families for pickup and drop off. And we also can allow that for visitors during the off times of pickup and drop off. So that works out really well. And then because we are going for the 77, looking to see how to make sure that when that time comes, we have space for everybody. And even though it's just momentary, you're only going to need it for a car for about 10 minutes for pickup and drop off. The church has kindly allowed us to use, and that's designated also in the diagram. You'll see the parking in 202 South Summit, which is the Ascension House parking lot. They've given us 40 spaces, which we don't even anticipate needing for the pickup and drop off, and then 10 for the staff. So we're adequately able to take care of that. The parents that would go to the Ascension parking lot to pick up and drop off would then use the crosswalk. It's highlighted for you to see, and that it's highlighted in purple, if you can see that. So that's a safe access and egress across the street. And then they can go down to our main entrance, which is also highlighted in pink. We can have a staff person at the top during the 15-minute interval if it's going to help with just cars coming in and out in 2 different spots. And the highest time we anticipate would be the 9 o'clock, because that's going to be the bulk of our kids coming in at 9. So we're going to use that system more likely at 9 o'clock and potentially at 1. The rest of the time, I believe, we'll be able just to use our current system of just using the lower level. And we also have families, just because it is a community school, we have families that still walk, walk their kids, or we have siblings in the same family. So that's going to even bring down the numbers of 77 cars. And we have staff that take public transportation instead of driving. And it's 2 staff that come in together. So again, we're really maxed out at the true number to match, but we don't anticipate that will even happen. Thank you.
Thank you. Appreciate it. We will proceed with questions from the board before we move on to any public testimony, if there is any. Any members of the board have questions?
So, first of all, thank you very much for the presentation.
Thank you.
And the write-up was very detailed.
Thank you, Dick.
I really only have a single question, which is about the outdoor playground facilities.
Okay.
With an increase from 55 to 77, almost a 50% increase. And I do understand that you've been granted access to classrooms inside to accommodate that. But that
Thank you
obviously
for
doesn't
asking.
change the outside space.
Yeah.
So how will that outside space accommodate that significant increase if you get to that number?
Okay. Thank you. Yes, there are 2 playground spaces for us to access. The one that's used primarily is already approved for 50-some students, and then there's additional space that's probably approved for 40. So again, that whole space in its entirety is, the State Department of Ed comes out and lets you know your numbers that are allowed in all the spaces. So we're good on that. It was always there. But thank you, I left that out. See?
Oh, no
It's
problem.
good somebody
I
catches that.
appreciate
Thank
the,
you.
I appreciate the information.
Thank you.
I've got a few questions.
Yes.
You stated this at the beginning, and I just want to be clear because this was my interpretation as well. You're asking for essentially formalization of what's already been approved by the Department of Ed.
Yes, by the State Department, and just to move it to 77. And Jasmine made us aware of that when we went to do a fire inspection. Kind of caught up with us, and we didn't know
Yep.
kind of the history and what to do. And so
Got it.
whether we ever get to that point, that would be great, but we just want it to all match.
Right, so which gets to my next question then, which is, this is a hope to expand to 77, to have the capacity to expand to 77? Do you have a plan? Or this is just, you
Well,
wanted to make sure that you had that? should
Well, I think you
demand
start
arise?
with that you're approved for that. You have the staff to do it, you have the credentials to do it, you have the space to do it.
Yep.
And therefore, you're ready to grow as that need arises. And we know that at some point, we were even at 52. So I think that's just where we are. We just want things to match. You can't have a license that says you're approved for 77, but the city of Gaithersburg just has us
Right.
approved for 55.
Yep.
So it made more sense to go that way and ask for your approval so that it all was together. And not that it just matched, but we also could serve 77 children.
Yep. And do you have an anticipated timeline that you're hoping to, or is this more of just in case?
Well, I think that every year, we after the pandemic, we were like 10 or 11. They just went down in numbers. Because again, we're mostly a private educational institution. And the families that seek our services really want it for the school part and appreciate that there's a before and after care. So it's not as a typical child care program would be, that's open more days, more hours. So I think we do outreach to a unique group of parents, but it's not necessarily as voluminous as those that just want a child care program that's open almost all but 8 days a year or something. So I'm not sure I'm answering your question, but yes, our goal is to get to higher numbers and eventually to 77 if that's.
Okay. You mentioned a couple times the spaces given by the Church of Ascension, if I got that right. Is there documentation of this? Is this a handshake agreement? Is it an understanding? Is there any
Yes,
risk that
it's
they
actually a
pull those
letter
back?
written, so it's in the document.
I missed
So
that,
the senior warden of the church, Kristen Keating, who's here, wrote that they have approved that.
Got it. And then when we look at what's up already, exhibit number 23, how different, not worrying about the parking because we've gone through
Yes.
that, but is there any difference in the flow of the entry and exit? Is this how it's all operating right now?
Yes,
Okay.
nothing would change.
And the last question, I think, current bell times at Gaithersburg High School are 7:45 to 2:45, right? what happens if the bell times change?
I think we can come back to the drawing board, and then I'd have to go through and find out what I'd have to do if we had to somehow change some of our arrival and departure times.
Yeah. I wonder if, and Frank, I'm looking at you for your thoughts on this potentially. Is that a condition that might make sense to add?
You certainly could. I don't know that that is one that's currently in place even for the
Yeah.
55.
Yeah.
But
May I say something?
the question would be how to word it so that
Yeah.
it's something that you can work with to say that you would adjust the time
Mm-hmm.
to try to avoid a conflict with arrival and departure
Right.
to the high school.
I was thinking about
Yeah.
this. I've got high school age kids myself, and there's a constant debate at all times.
You're right.
about
They
the,
want
the
to.
change
They're
of bell
sleeping for
times.
the first period class. So they're always trying to move it up. The problem is transportation dictates a lot of what the bell times are like because they have to
Yep.
transport from. And now they're going to be expanding ages they serve. They're expanding younger kids too. So I think if it does change, I think it's going to be a matter of 15 minutes. I don't think it's going to be an hour. I don't think it's going to be like 9 o'clock in the morning that high school kids are going to school, because that wouldn't take care of all the elementary kids that have to get to
Right.
school. I don't think it will, but certainly if there's a caveat that allows the leverage for that, rather than the monitoring of that, I don't know.
Question for
No, I was just considering the idea of a condition on the timing. And obviously, that's not a for now thing that we know about. But right now, I believe your timing is at least 15 minutes off of 30 minutes off of the
Well,
schedule.
you're right. I mean, it's 7:30. Are you saying from the morning?
Well, so your morning is 15 minutes off of the
The
morning
buses
schedule.
are all gone by 2. For the Gaithersburg are finished by 2:45. They're on the road and out. They start picking up around 2:20 to 2:30. They
Okay.
let them out even earlier.
Okay. All right, thank you.
Any other questions? Gotten through my litany. Do we? Is there anybody else in the audience who would like to make any public testimony? Guess not. Okay. Is there a motion to close the record? Got to you guys.
Do we close the record before discussion?
Yes.
Then I will so move to close the record on application BOA 941020022.
Second.
All in favor?
Aye.
Aye.
Passes 3-0 to close the record. So we kind of began discussing anyway, but you guys want to start? Any impressions, thoughts?
It seems reasonable that they have all the accommodations there to accommodate more kids.
I think the plan's well laid out. My main concern was the outdoor space, because it was clear the indoor space is sufficient, along with the parking is sufficient. With the answer about the outdoor space and the state already evaluating that for the numbers, I have no concern about that. I am interested, I think, in discussing a little bit about that condition that you suggested.
Yeah.
Maybe something along the lines of that the in and out times are always X number of minutes off from whatever the school's in and out times are,
It almost,
or at least X number.
yeah, it almost feels, if we wanted to add a condition to the resolution, that almost feels too detailed. I wonder if it could just be, this is in place unless the bell times at the schools change, and then we come back and rehear.
If we added a condition, though, that was specific enough so that it could be followed, if the times changed, would it be necessary to come back to the
Right.
appeals board?
It's more about the getting the wording right.
Yeah. Because that would potentially, I think, allow compliance without incurring any additional time cost or anything like that.
Yeah,
But yeah, you're right about the wording.
yeah. Let's put it aside for a second. Yeah,
Yes, if I could make a recommendation,
Yeah.
you could make the condition to leave it to staff to review that time change to determine if it's still acceptable and meets the discussion tonight.
that would be, yeah.
I like
if
that.
If that's a permitted, if that's a,
Thank you.
We, I think it has to come back to the Board of Appeals because we could not change the conditions of their special exception.
So there's condition number 2, operating hours are limited to
Right.
the hours specified in the applicant's statement. So I guess any changes to that, those times will have to come back
right.
to the board.
Which doesn't require, just to be clear, a complete, full new special exception. It can be just a review of the special exception. It might be that the applicant comes back and with evidence that is no conflict and everything can remain the same, or or that they will change their times and we just amend that one condition. But staff can't change that condition without coming
Right.
back to the board.
And as it exists currently, the condition is simply that the operating hours remain the same. So if the school's operating hours changed, under the way it's currently written, there would be no requirement to have to even examine that, right?
Right.
Okay. So, I mean, it sounds like if we wrote a condition that if the school's hours were to change, maybe the most effective way of doing that is simply that it would have to come back with a proposal to adjust the operating hours.
Right.
I'd have to.
You could say something like applicant to return to the Board of Appeals for a review of meeting or of operating hours should Gaithersburg High School bell times change.
Yeah, that's kind of what I was
Yeah.
getting at, not very eloquently
Yeah.
prior. Is
Not
that,
sure.
if we proceed with that as amended, we've kind of captured the essence and we'll be able to draft it, okay. So putting that question aside, otherwise, my perspective on it is, it's permitted use by special exception, doesn't disturb the neighborhood, it's continued use, it's approved by the Department of Education, there's no reason I would say otherwise not to approve.
I'm in line with that.
Is there a motion with respect to the application resolution?
I make a motion that the Board of Appeals, based on the findings and conclusions outlined in the draft resolution, and with the condition that we discussed, approve special exception application BOA 9410-2022 and adopt the resolution BOA 9410-2022 with the prior 4 conditions plus the additional one presented.
Is there a second?
Second.
All those in favor?
Aye.
Aye. The motion passes, the resolution passes 3-0. Thank you so much.
Thank you so much.
Good luck. Okay. On to our third item for the evening, administrative review. This is a petition for administrative review of a fence permit issued for 211 Sportsman Way. This is case BOA 9387-2022. Staff wants to start with presenting the official record.
Sure. Before I do that, I just want to let both sides know how this is going to operate. So all of you are welcome to come to both of the tables. The petitioner will be at the further table and city over here. And I've just been asked to tell everybody, don't move the microphones and don't move the positioning of the chairs because otherwise you won't be captured either by audio or video. So, and the podium in the center can also be used for anybody that wants to speak that's not in front of a microphone. We can only have 2 people at a time at the, that's the chair that shouldn't you're going to keep the chair where it was. Otherwise, you won't be on camera. You have to move over. Where, yeah.
Okay.
It's just because this room is not typically, it's not accommodative of this kind of setup, but every once in a while we have to do it that way.
It's like American Idol. You have to stand on the ends.
So if either party has a third person that wants to testify, or you want to switch out people at the desks, feel free to use the podium as well. With that, I'll go ahead. This is a public hearing on Board of Appeals, case BOA 9387-2022. The hearing was published in accordance with the requirements of the city charter and code on the city's website. At the present time, there are 44 exhibits in the record files. They are referenced in an exhibit list in the files. The individual exhibits may be reviewed during the course of the meeting or in the Planning and Code Administration office during regular business hours at City Hall or on the city's website. Any objections to the receipt of any exhibit should be noted prior to the closing of the record. Otherwise, they will be deemed received in evidence. Petitioner and property owner at 209 Sportsman Way has requested an administrative review of the issuance of city fence permit FENC 28847-2022 in accordance with section 24-167 of the city code. Property in question is located in the R90 cluster, medium-density residential zone at 211 Sportsman Way, Pheasant Run, Gaithersburg, Maryland. I will turn it over to the chair. And
Thank you. Quick couple of notes and reminders for the group, because for us, administrative reviews are a bit less typical than special exception. In the case with an administrative review, our authority on this comes from section 24-187 sub A of the zoning ordinance, which states that administrative review is meant to hear and decide appeals where it is alleged that there is an error in any final order, requirement, decision, or determination made by any administrative official or department of the city government or the planning commission or historic district commission in the enforcement and administration of this chapter, the building code, subdivision regulations, or any other ordinance or regulation which may hereafter be designated by the city council for such administrative review, provided, however, that appeals alleging error by the planning commission or historic district commission shall be by oral argument or written statement based solely on the evidence submitted and received in the planning commission or historic district commission proceedings. In hearing an administrative review, the following findings must be studied by the board as outlined in section 24-18 sub A. Findings required for administrative review. A petition for administrative review may be granted when the Board of Appeals finds from the evidence of record that the final order, requirement, decision, or determination, which is the subject of the appeal, was clearly erroneous or not in accordance with the law. So in other words, was there a legal order, or was there a mistake of fact in issuing the permit originally? We are going to, for this proceeding, which is a bit unusual for us, as I mentioned, want to lay out just a little bit in terms of procedure, including some time limits unless there are significant objections. We are going to have any additional guidance from council here with respect to the administrative review. We'll administer the oath for anybody testifying who's not council. Give the petitioner the opportunity to present. We're going to limit that initial presentation to 30 minutes. Then there'll be questions to the petitioner by the board. Presentation then by the city, also 30-minute limit, and questions again from the board. And then an opportunity for any other interested parties from the public to testify. We're going to limit those to 3 minutes each. After public testimony, the petitioner will have an additional 5 minutes for any rebuttal evidence, at which point we will close the record, and then there will be opportunity for closing statements on each side, 5 minutes each limit on the closing statements. Is that procedure clear?
Yes,
I can repeat
thank you.
any if needed. Okay, very good. Begin with any additional advice, council, for the board, including the fact that we received just prior to this hearing a couple of motions from the city. A motion a motion to dismiss and a motion, and I never get the pronunciation right, eliminate, with respect to limiting the evidence.
If the board is interested in considering those motions, I would not advise that that be considered against the 30-minute
Yes.
timeline to present the case, but it would make sense that any motions be heard preliminarily, for the board to then decide, as that may determine how the hearing proceeds from here.
Yes.
Michelle Rosenfeld, legal counsel for the petitioner. Two preliminary things. First of all, I have a letter here to enter my appearance in the record. I don't know if I need to formally do that in writing, but I am entering my appearance in this case. And I have an objection to the board taking up both of those motions. And before they're presented, I would ask as a preliminary matter that I state my objection to the board hearing those before oral argument would be considered, should you consider it.
Fair enough. Thank you. I appreciate that. As I mentioned a couple of times, some of this is new to us, so we're going to lean heavily on counsel with this, which kind of was a surprise to us. I know in previous discussions where there have been sort of preliminary motions, we've had almost a policy conversation around considering the motions to dismiss or to limit evidence. I don't know if you have thoughts on that, or if we should proceed directly with consideration of those.
When you say, I'm not sure what you mean by you've had
Well,
prior...
whether for the benefit, whether we would even consider a motion to dismiss or limiting the evidence because of,
that is the board's purview.
Mhm.
You can decide we're going to proceed with the case and move along, or you can, that's the board's
Yep.
option, or you can hear them, and it is your option if there's an objection to even hearing them. You certainly could hear what the petitioner counsel
Yep.
has to offer. That's entirely up to you. You could do that.
Or comment? Okay.
We could, I think we could listen to it and decide.
And I apologize for interjecting, but if you are considering hearing the merits of the motions, before you do so, I would like to note my objection on the record as to why I think you should not hear them tonight.
Chair,
Yeah.
I feel like if we are going to consider the motion to dismiss, we need to consider it prior to general testimony.
Yeah.
But I think it's probably also fair to hear reasoning as to why we should or should not consider the motion.
I think that's right. So, unless there's objection, we'll start with hearing the motion and hearing your response.
I first would like to at least note on the record why I object to you hearing the motions at all tonight. And so for the record, there are two motions that were filed.
Right.
I received them at 4:30 tonight. The hearing was set for 7:30. One is a motion to dismiss the case entirely on its merits, and the other is a motion in limine which seeks to circumscribe the evidence of record that would be presented to you. Both of these one would be dispositive. The motion to dismiss, if granted, would entirely moot the appeal. The other one has the potential to severely curtail the evidence and legal arguments that we would be able to make this evening to the board. Should the board elect to entertain these motions, it would be highly prejudicial for you to do that this evening. I have not been in a position to review the statutes. There is case law that is cited in both of these motions, I believe. Certainly the first case law cited in both of these motions. You have a written motion in the record, and it's prejudicial to my client for you to hear the merits of these motions without me having an opportunity to respond and be able to articulately defend my client with respect to both of these. Should you decide you would like to hear these motions, my request would be that we defer the hearing tonight to give me an opportunity to submit a written response and be able to address this on the merits in a way that my client can be fairly represented, given the extraordinarily short notice that we got that this would even be considered tonight. So that would be my request. Either do not take them up, or if you do, give me an opportunity to, we don't need a long postponement to your next agenda, whenever that might be, but at least a reasonable amount of time for me to be able to respond to these on the merits. Thank you.
If I may respond. As to both motions, the motion to dismiss based on a claim upon which relief cannot be granted, based on Maryland Rule 2322B, is by definition a permissive preliminary motion, meaning that it can be brought before the hearing, right before the hearing starts, or even during the hearing. And that is because the whole point of a motion to dismiss upon which relief cannot be granted is a matter of law. Whether or not it would be prejudicial, the fact that you can bring it at any time, and the fact that opposing counsel was just brought into this case, that's sufficient enough time for opposing counsel to look at her client's pre-hearing statement, determine whether or not, based on Section 24167, a legitimate claim has been brought, and prepare for a potential motion to dismiss. As far as a motion in limine is concerned, those motions are typically brought within the hearing itself, can be oral. There's no rule in the Maryland rules that states that these motions are required to be in writing. They can be oral. If I didn't file this in writing today, I would have made the motion orally, and that would have been within the Maryland rules as far as legitimacy is concerned. Without getting into I think we're dealing with whether or not we're even going to talk about the motion right now, but based on what I've said, I think we should entertain the motion if that is the case, and the board is willing to include these motions in the record. I don't believe they have been yet.
No, they have not.
So if they are admitted into the record, I will submit as far as the content of the motions themselves. But even so, the reason I can bring forward these motions at such short notice also is for the preservation of issues on appeal. The city is well within its right to preserve a motion to dismiss upon which relief can be granted in order to, in the event that petitioner does appeal it to the circuit court, I can then bring it forward. If I don't bring it up, I waive it. So for all those reasons, I think that the board should at least entertain and hear arguments on the motion to dismiss and motion in limine.
And briefly in response, with respect to the motion to dismiss, the city relies on Maryland Rule 2-322 in support of the timing of this. That rule comes from the rules of procedure for the Montgomery County Circuit Court or for the Maryland Circuit Courts. It is not a rule that governs administrative proceedings. It's not a rule, certainly, that has been adopted by the city of Gaithersburg in terms of the Board of Appeals rules of procedures. So I just don't think that pulling the rules that govern a trial into an administrative proceeding is an appropriate legal basis for bringing this at this time. And for the same reason that the city wants to preserve these motions in the record, regardless of whether they are granted or denied, for that reason, it's important for us to be able to protect the record with a thoughtful response. And there is nothing, this is not a temporary restraining order. This is not a preliminary injunction. This is not a case that has immediacy. And in the interests of fundamental fairness and due process, I think my client should have a reasonable amount of time to be able to respond to these two motions, which really both go very much to the core of her case in the first instance and the scope of her evidence in the second.
Thank you. I think it's worth us having a quick discussion on what we just heard. Your thoughts on proceeding with either or both motions?
If I may add something really quickly to potentially help you, if the board is so inclined to deny the motions, all I ask is that they are included in the record to preserve my appealability. That is the main crux of filing these motions. So with that, I would submit.
Thank you.
Just by way of guidance, your decision as to what to include in the record is at the close of the hearing, so you certainly could defer taking action until hearing the case. I mean, that is what you're here to do tonight, and that would not necessarily prevent you from choosing to move on the motions at that time if you wish to do that. But then your decision to include them in the record would be made, could be included at the end of the proceedings, because that'll come after each side has presented their case.
Right, understood. Yeah.
So, gosh, I have a lot of thoughts on this. First of all, to the question of whether or not we should be using judicial rules and precedent, I do understand the argument. We are a quasi-judicial body, and if we don't have guidelines to go on, I feel comfortable using guidelines that have been litigated is the wrong word, but come up through case law and experience and have worked in other places within the state and the county. So leading on that, following what's found in those environments for accepting these types of motions orally on the spot, et cetera, I think sounds reasonable to me. To the question as to whether or not we should postpone the hearing to give everyone a chance to prepare based on motions, on the one side, there is kind of the question of the immediacy and the possible harm that could occur by not giving that appropriate time. But once again, I then lean back on my original statement, which is these motions can be made in a judicial setting orally at the time of the actual trial, and I think that I'm inclined to continue with that idea and following those precedents. So I do think that we should accept hearing them now, just based upon that history.
Anything to add?
Could I ask a question? Okay. So what was the timeline you were expecting to receive the information? Because you said you received it today at around 4 p.m.
I would expect, based on the rules of procedure of the board, that these types of arguments would have been presented as part of the pre-hearing submission. As far as I'm concerned, these are an amendment to the pre-hearing submission. They are legal arguments made in opposition to the legal and factual information that we provided in our timely filed pre-hearing submission. And while I do appreciate that these arguments can be made under the court rules and during court, and I practice in the courts a great deal. However, you have in front of you written arguments that are supported by references to rules, by references to case law, several cases. Those are not things that necessarily would just spring out from a lawyer's oral argument. And so And there are often case instances where the court would then take it under advisement if that kind of legal authority is presented. So again, I think it's untimely, I think it's unfair, I think it's prejudicial, and I do think that it should properly have been filed at the time of the pre-hearing submission.
If I may respond. A motion to dismiss is not an amendment to any initial pleading that is filed before judicial or quasi-judicial board or court. It is a dispositive preliminary motion, and it's permissive based on subsection B of Rule 2322. That means that whoever's bringing that motion has the ability to bring that motion at any time, moving up until the date of the hearing, the time of the hearing. Based on what opposing counsel is saying, she is interpreting my motion. My motion to dismiss adds no additional facts, no additional instances or events as to what happened in this case. It's simply an argument based on a matter of law. Did the petitioner argue a claim upon which relief can be granted? That's all that the motion is requesting that the board today find. It doesn't add anything else as far as facts is concerned. So to interpret the motion as an amendment to the pre-hearing statement is just incorrect. As far as postponing this hearing, if we're going to talk about prejudice, I think we need to take into account the prejudice that the permit applicant, Rachel and Fernando Maturana, would face. This has already been postponed once, and I believe that any further postponement would greatly prejudice the permit applicants in utilizing their property in a manner in which they legally have a right to do. Based on the facts of the case, they've paid a substantial amount of money to the contractor, and this project has been delayed quite some time now based on the previous postponement. Postponing it again, I don't think would be in the best interest of the board, in the best interest of the city or the permit applicants, and I don't believe that based on the fact that the motion to dismiss is a matter of law. I don't believe that the petitioner is suffering any prejudice at this time. Again, I will, as opposed to postponing it, to be completely frank, I would rather the board deny the motion to dismiss and include it in the record in order for the city to preserve it and move forward today. With that, I submit.
Thank you.
Very briefly, I promise. My understanding is that the people who applied for the fence permit have lived in their home for probably more than 15 years. It's hard for me to see how a several-week postponement would really prejudice them from their ability to use and enjoy their property. And if the board, I would object to just a summary denial of the motions and including them in the record. If the board is going to, I would object to them being included in the record at all if we don't have an opportunity to meet and fully respond to them before you decide. Thank you.
Thank you. Any further thoughts? I'm sympathetic to the surprise, the last minute motions. I also think that we are a quasi-judicial body. We have a little bit of leeway in how we manage the procedures here and the choices that we make in terms of what we hear and the limits that we put on them. I think hearing your objection, having your objection in the record, having an opportunity to hear the motions and discuss those motions and rule on those so that we can proceed with assuming we do proceed with a timely hearing tonight, I think is in everybody's best interests. So I think what we will do is go ahead and we will hear the motions one at a time. Set a limit. Let's say 5 minutes for each motion and response, with another 2 minutes for rebuttal if needed.
Sure.
Work for both sides?
And, I mean, I can,
You want to
I can
set a
simply,
timer?
Yep.
We're going to have a timer set
Sure.
for both, for all of these, just so everybody knows. The timer will start counting down from the time limit, and I believe when there's 1 minute left, there'll be a light that comes on, so everybody will know.
It might be 1 minute, it might be 30 seconds.
Oh, it might be
I don't
30
know.
seconds.
We'll find out together.
I can't
As a
remember.
group. Okay.
sure. A motion to dismiss for failure to state a claim upon which relief can be granted is a permissive preliminary motion that may be made after any responsive pleading, such as the pre-hearing statement, is filed, including and up to the day of the hearing or trial. What is the board entertaining when they receive a motion to dismiss? Dismissal for failure to state a claim is proper only if the alleged facts and permissible inferences from those facts, if proven, would nonetheless render a claim inaffordable to the petitioner. The sole question for the board here today is whether the city's decision to approve fence permit application number 28847 2022 was clearly erroneous or inapplicable with respect to section 24167 of the city code. That section is the sole provision within the city code that deals with the proper procedures and regulations as to whether or not the city can approve a fence permit application. In her pre-hearing statement, the petitioner makes various allegations that the proposed fence would aggravate or otherwise cause her yard to flood any more than it already does. In support of those contentions, she cites to various code sections throughout the city code as to why that fence should not be allowed based on that alleged aggravation of the flooding. Flooding, whether it happens or not, is not a criteria that the city takes into account when making a decision as to whether or not to approve a fence permit application. So if that's the basis of her pre-hearing statement, which it is, there's no claim, there's no relief that this board can give her, even if she proves beyond a reasonable doubt that this fence will in fact cause flooding to her yard or aggravate the flooding that already exists. Even if the board were to find that 100% it does, it would still have to deny her application for administrative review because the city official, their approval of the fence permit was well within the confines and the boundaries of section 24167, which only calls for an analysis of fence height. That's the only specification of the fence that section 24167 takes into account, is how high it is. There's different regulations based on whether it's a corner lot, whether it's an abutting lot, as to how high it can be. The petitioner makes no argument as to her complaints regarding the height. Her only complaint is that this fence may or may not obstruct the natural flow of water from her property into her property, into 211's property. Alternatively, the petitioner requests that this board impose a condition on the fence permit application that it be raised 6 inches from the ground. that imposition or that regulation is not found within section 24167. So this board is without power. It doesn't have the legal authority to impose such a condition because it's just not found in the city code. Those are her two main arguments within her pre-hearing statement. None, even if, again, I repeat, even if the city were, even if this board were to find that the fence would cause flooding to her yard, it would be compelled to approve the city's decision of approving the fence. And with that, I would submit.
Thank you. And I think we all just collectively learned that we get to beep at 30 seconds.
30 seconds.
Yes.
Not a minute. Thank you.
And the beep is very loud.
Yeah. Petitioner.
Yes, thank you. The city's motion to dismiss is based on an argument that really disregards an array of both statutory authority that we include in our arguments, as well as evidence that was presented in our pre-hearing submissions. In addition to the code section that was cited by the city, Code Section 24-165A8 says structures, including fences, and I'm deleting some text here, but then goes on to say, may be built within a building restriction setback, as this one is, so long as the location of the structure does not interfere with the use of any abutting property. And it's our argument that construction of this fence, as it's designed right now, will interfere with the use of my client's property. In addition to that, City Code Section 24-167.5, which regulates fences, says the goal of the statute is to, quote, protect public health, safety, and general welfare, end quote, giving some broader discretionary authority with respect to reviewing and approving fence permits. In addition to that, Chapter 8 says no person shall dump by any dump, move, place, grade, excavate, fill, or by any action cause or permit any soil, earth, sand, gravel, rock, stone, or other material, or water or liquid to be deposited upon or to roll, flow, or wash upon or over the premises of another in a manner to cause damage. And it's our position that the fence, as it's designed, which is essentially going to be flush with the ground, will result in that. And finally, in addition to that, we have information, we have in the materials that we provided, Section 24-172, which says that land which is the subject of an approved site development plan needs to be amended before you construct any building or structure in a manner that's not in compliance with that plan. And to do so constitutes a violation of the chapter. And the evidence that we have submitted in the record includes the plats that show that the property that's the subject of the fence permit, in fact, is the subject of a site plan. And so a site plan amendment would be required in order to secure a fence permit at all. So it's our position that the arguments that the city is making, without getting into the full-blown merits of our case, of course, but we make a number of colorable claims and statutory arguments, factual evidence that show that we have that our appeal is premised on legal authority and evidence that goes beyond the narrowly constructed reading of the fence provision that the city is relying on with respect to its motion to dismiss.
Thank you. You have 2 minutes for rebuttal.
Sure.
Sum up.
With respect to opposing counsel's argument regarding Chapter 8, which prohibits people from dumping or placing water onto another's property, a fence doesn't in any way create or in of itself push water onto another property. If a fence were to emit water, then perhaps Section 8 would come into would be relevant, would come into relevance. but it doesn't. I repeat, the only provision that governs the city's ability to deny or approve fence permit applications is 24167. No other city code chapters are relevant to whether or not the city may or may not approve a fence permit. With respect to subsection 5 of 24167, opposing counsel said that, raised that a fence or wall shall not be detrimental to the public health, safety, and general welfare, but opposing counsel fails to include the entire language of the subsection. A fence or wall of a height greater than 6 feet may be erected with the approval of the city manager or designee upon a finding that the fence or wall will not be detrimental to the public health, safety, and general welfare. This fence is not going to be above 6 feet. It's apparent based on the fence permit application that it's 6 feet. So whether or not it will be detrimental to the public health isn't something that this board has to decide upon. I believe the opposing counsel also mentioned
I'll let you finish the sentence, but
24165 with respect to setbacks. 24167 specifically states that setback requirements of this chapter shall not apply to fences or walls. So as a matter of law, based on the language of the subsection, the fence is well within its rights to be erected in that area.
thank you. As a board, considering what we just heard from both sides, my initial reaction is that it went as I suspected, that we would begin to hear the merits of the case, and that we chose to proceed tonight so that we could proceed in expediency and put some limits around the extent to which this argument goes further. My initial reaction is to deny the motion to dismiss and hear this out as initially planned, but we can hear the second motion.
I have a question for our city attorney. On the matter of whether or not the approval was in accordance with law, must that be considered only in Gaithersburg Law and Code, or if there is applicable code and law and case law from Maryland as a whole? Is that something that we should consider as well?
Well, the term would be applicable. So if there is, for instance, we are operating as a public body within the confines of the U.S. Constitution. So certainly if there was a problem there in terms of giving people a right to be heard, et cetera, that would apply. So we're not necessarily restricted only to certain sections, but of the code in terms of making a decision. But that depends on what's being alleged, and here with the fence permit, there may be some limited sections that apply, but that's part of the ultimate decision you have to make really at the end of the case as well.
Sure, thank you. On the one hand, within the strict confines of what we have to consider whether or not the approval of the permit has potential relief from us, which I think is really the question for the potential dismissal. And that's based on, we're limited to considering whether or not the approval was made in error, or whether the approval did not follow the laws that should be applied to this. Excuse me. I'm leaning towards that I'm having difficulty seeing where we're going to have leeway to find something that's within our code that wasn't followed based on what's been said. But at the same time, there is a greater realm of law, like you mentioned, potential state cases and such that could affect that. Because of that, I think I agree with you that we should continue forward.
Phil, anything to add?
Yeah, I agree.
I don't think we need to put this to a vote.
I think the record can reflect that there was a consensus that the motion to dismiss would be denied.
Yes, thank you. Let's proceed then with the motion and eliminate, and as we do, using the same limitations of 5 minutes, 2 minutes, to the extent possible, if we can focus on not the merits of the case, but the argument of limiting the evidence, I think it'd be most helpful for moving this along tonight.
Sure.
And hang on one second.
Oh, okay.
I don't know what happened here. Let's try that again. There you go.
Okay, so to start off, the Board of Appeals Rule of Procedure 5.1D permits this board to exclude incompetent, irrelevant, immaterial, and unduly repetitious evidence. As defined by Maryland case law, relevant evidence is evidence which tends to establish the fact at issue, in this case, whether or not the city official abided by Section 24167 in approving the fence permit application, or that it has consequence to determination and is logically related to a fact at issue and has sufficient probative value. The sole question for the board to decide in this hearing for administrative review is whether the city's decision to approve the fence permit application was clearly erroneous or not in accordance with Section 24167. Section 24167 is the sole provision governing the procedure and regulations regarding the installation of fences within city limits. Section 24167 does not contain any provisions that require the city to analyze a proposed fence's potential flooding impacts on neighboring properties as a condition to approving a fence permit application. Therefore, any evidence or testimony related to past or current flooding of the petitioner's property is wholly irrelevant as to whether the city's decision to approve the fence permit application was legally valid or invalid or clearly erroneous. Given that, I believe that any inclusion into evidence, any testimony regarding flooding or whether it's prior or current flooding would convolute the issues at hand, which is the criteria within 24167, which does not include flooding. Any discussion of flooding would add to the confusion, would be irrelevant, and would spend the resources of the board unnecessarily. And with that, I submit.
Thank you. An opportunity for about.
Yes, thank you. For the reasons that you decided to move on to the merits of the case, those are precisely the reasons why the evidence that's going to be presented will go beyond the scope of simply the fence review process itself. We've already identified for you several other statutes that we think are implicated. The visual evidentiary evidence that we have included in the record goes to those statutes and why it's important that this case be considered on its merits beyond just that one narrow provision that the city relies upon. As I mentioned in the prior argument, for example, we have plats that demonstrate that the property is subject to a site plan, and there's a statute that says that if you're going to build a structure, you need to get a site plan amendment in order to do that. The evidence in this record is that that did not occur. We also, to the extent that there are arguments that a fence does not affect flooding, in this particular case, we submit that the evidence will show that it certainly could have a material impact on flooding. So I appreciate the city wants to really make this a very, very narrow case, but our appeal is premised on several statutory provisions and on a broader range of evidence. And We submit that in order for you to appreciate our full argument, we need to and are entitled to present that legal authority and that evidentiary information to the board for your consideration.
Thank you.
With respect to,
Hang on one second.
okay.
You gotta bear with me on this. Very simple technology that I'm still learning. And I see that I can change it. Well, whatever I just did, the warning is now 1 minute instead of 30 seconds. 2 minutes.
With respect to site plan amendments, this fence permit application is not a site plan amendment. The approval of a site development plan, an SDP, is for the purpose of major developments within the city. A fence or any similar fixture installment on property doesn't fall within the realm of what a development plan is meant to encompass. Due to that, the sections regarding site plan or the amendment of site plan developments are wholly inapplicable in this case. This is not a site plan development, it's a fence permit application. There's no developing that is intended to occur on 211 Sportsman Way. All that's being requested is that a fence be erected based on 24167. 24167 was not followed. It was followed. 24167 does not require an analysis of whether or not the fence is going to obstruct water. So for those reasons, any discussion of flooding or causes thereof should not be relevant, should not be considered by the board.
Thank you. See if that works next time. Quick discussion of consideration of the motion and the arguments. I feel very much like I did in the previous motion, which is these are exactly the elements of what we're planning on hearing. It's these questions of should it be limited to 24167? Should the broader sites apply? So I'm inclined to deny this motion as well and proceed.
I agree.
I would agree with the chair.
We have consensus again. The motion is denied and we'll proceed as planned with the petition for administrative review. Reminder of something that was mentioned quite some time ago. Our procedure will follow. We'll quickly administer the oath to any witnesses, not counsel, who will be testifying over the course of the evening. 30 minutes to the petitioner, followed by questions from the board. 30 minutes from the city, followed by questions from the board. And then 3 minutes testimony each for any members of the public who'd like to testify. 5 minutes rebuttal by the petitioner. We will close the record and offer 5 minutes closing statements for both sides. So anybody who is planning to testify this evening, would you please rise? Please rise.
So the first time
That's okay. This is my first time running an administrative review. I hear you. Raise your hand. Great. Do you solemnly swear and affirm under the penalties of perjury that the testimony you are about to give or will give this evening in this matter shall be the truth and nothing but the truth?
I do.
Great. Thank you. We'll start with 30 minutes for the petitioner.
If I may, just before we start, I
Yep.
just wanted to let
Thanks,
both
stalling so I can do this.
both parties know, I have all of the exhibits available to pull up on the screen. I know it may be a little awkward for anybody, for you to see them, but they will be there, and if you would prefer to speak from the podium so you can see whatever's on the screen, feel free. If any exhibit you want to pull up, just let me know the number, and we will pull it up.
But that also means that those exhibits would be available to the board,
Yes.
which is the important point.
Right.
And quick moment, I've figured out at least one component of this. So the warning will now be at 3 minutes. Since we're at 30 minutes, you'll get the warning at 3 minutes to give you a little bit of a head start on wrapping things up if we go that far.
Chair,
Yes.
before we start, can I run to the bathroom?
Very, very polite of you to ask. How about this? Is there a motion to take a 5-minute break?
Please.
Okay.
Second.
Second. The motion to take a 5-minute break is passed. All right.
She works the nights by the water. She's gone astray, so far away from her father's daughter. She just wants a life for a baby. All on her own, no one will come. She's got to save him. She tells him, ooh, love, no one's ever gonna hurt you, love. I'm gonna give you all of my love. Nobody matters like you. She tells him your life ain't gonna be nothing like my life. You're gonna grow and have a good life. I'm gonna do what I got to do. So rock-a-bye, baby, rock-a-bye. I'm gonna rock you, rock-a-bye, baby, don't you cry. Somebody's got you, rock-a-bye, baby, rock-a-bye. I'm gonna rock you, rock-a-bye, baby, don't you cry. Rock-a-bye. She found her love way too early. He left her there with more than tears and hurt to carry. They said too young, what are you thinking? They told her to, she chose to use her heart and keep him. Now she got a 6-year-old, trying to keep him warm, trying to keep out the cold. When he looks in her eyes, he don't know he is safe when she says, ooh, love, no one's ever gonna hurt you, love. I'm gonna give you all of my love. Nobody matters like you. So rock-a-bye, baby, rock-a-bye. I'm gonna rock you, rock-a-bye, baby, don't you cry. Rock-a-bye. Now she got a 6-year-old, trying to keep him warm, trying to keep out the cold. When he looks in her eyes, he don't know he is safe when she says, she tells him, ooh, love, no one's ever gonna hurt you, love. I'm gonna give you all of my love. Nobody matters like you. Yeah. So rock-a-bye, baby, rock-a-bye. I'm gonna rock you, rock-a-bye, baby, don't you cry. Somebody's got you, rock-a-bye, baby, rock-a-bye. I'm gonna rock you, rock-a-bye, baby, don't you cry. Rock-a-bye.
Great. Resuming after a brief break. Scanning the room, I don't believe I see anybody new who may not have been sworn in for testifying, but is there anybody new in the room who needs to be sworn in? Okay, great. I want to make sure we cleared that. And counsel for petitioner, you may begin.
Thank you very much. For the record, Michelle Rosenfeld with the Law Office of Michelle Rosenfeld, and with me to my right is the applicant. Would you please state your name and address for the record?
My name is Ionna, Tzioumi, 209 Sportsman Way.
And if we could pull up exhibit number 33, please.
Showing up, there it is.
Okay. Are you familiar with exhibit number 33?
Yes, I am.
And what is that exhibit?
This is the survey plan that the applicant submitted, the second one, for the approval of the fence.
Okay. And looking at exhibit 33.
Recording in progress.
Would you please explain to the board members where your house is located? Is it to the left or to the right of this exhibit?
To the right.
Okay. So there's Trudy Way, the fence property, and then your property? Is that
Yes.
correct? Okay. Thank you. If we now could please go to exhibit number 35. Looking at,
I'll zoom in.
Yes?
let's let her pull it up.
I got, hold on a minute. Okay.
Okay, if we could look at drawing your attention to the exhibit number 35, starting first with the image on the right that's in color. Going from the right to the left, could you identify which is the fence property and which is your property?
So the first property at the corner, the first red line, it's property 211 Sportsman Way. The second one with indication 432, which is the isometric. And so the second red line, it's our home, 209 Sportsman Way.
And looking at this image on the right, which direction does water flow?
The
Objection.
flow of
Objection
the water
Objection is to the relevancy. And
from
in order to.
north.
We're gonna let him
Wait,
proceed.
wait,
Well, just in order to refrain from continuously interrupting her, I would just note that I have a continuing objection as to any testimony regarding water.
It's just heard and noted on the record with the motion eliminating. Understood. Thank you.
So the water flows towards the north towards the south, towards 211, because north is higher grounds, which is 207 Sportsman Way. West is higher grounds, which is 2D4. So the only way for water to go is downhill, which is 211 Sportsman Way.
So are you uphill from the property that's seeking the fence?
Yes,
Okay, so the water would flow from your property to theirs, is that correct?
yes.
Okay. And then looking at the image in the upper left, there's a notation there, 1980 Locust Grove Way. Can you explain to the Board of Appeals what that reflects?
So that was a plot that I was given a long time ago. And this one was supposed to be an approved plot. And our yard is shaped very much like this plot. The only problem with this plot is that 211 is not at the same line with our home. It's placed like a corner property. It's diagonally. So the location of the house, of the 211 house, is not as it is today. So in this, now that was an approved plot from City of Gaithersburg, and I was also given a seal for that. It's S-609. I don't think, there were many changes on this plot, but even in this plot, you see we have a big swale that funnels water towards south, towards 211, that according to this plot would be Trudy 2 or 2 Trudy. And then it spreads, and also this one has swales to the left and to the right that pushes water to Trudy and to Sportsman. So that was the plan back in 1980.
And so does the plat show grading lines? Does it show the topography of that site plan?
Oh, yes,
Okay.
yes.
If we could go to exhibit number 32, please.
Which one is this one? Oh, okay. So that...
Wait. Then she'll have better pull it up.
It's there.
Okay, I can't see it.
Sorry.
So, thank you. Looking at exhibit 32, do you recognize what that document is?
Yes, this is the seal for a final site plan from 1980, and that's supposed to be the proof that S-609 was an approved plan for this location.
And it says site grading plan Pheasant Run. Okay, and would that be the same subdivision plat that we were looking at a moment ago, the 1980 Locust Grove
Yeah,
plan?
the differences are, for example, Sportsman back then was in that plat was referred as Locust, and Pheasant Run was referred as Watkins Mill, like the other side of Clopper Road is called.
Okay. Now, I would like to draw your attention to exhibit number 27, please.
So,
Thank you. Could we please go to page 168 of that exhibit? Do you have an existing fence on your property?
Yes.
And is that fence shown on page 168?
Please let me see up there.
right here.
Yes,
That's it.
yes.
Okay.
Mhm.
And can you describe the fence that's on your property?
It is a privacy wooden fence, which is board on board the opposite way, but it's not impermeable. Water can go through, and otherwise, yeah, it was installed by the previous homeowners.
And where would the new fence be built in location, in relationship to the fence? Let me orient everyone to the image on the top left-hand side of page 168.
So the fence would go exactly parallel the second fence, that vinyl fence, would be exactly parallel to our already existing privacy fence. And our fence is supposed to be about 6 or 7 inches from the property line that we know of. We started a survey that we never finished, so we're still in progress. And I guess they would have to retreat from the property line like 2 or 3 inches like this, people usually do. So it would be like, I don't know, 10 inches among them. It wouldn't be more. Yeah, I would be among the trees, but here the trees look much closer. In the other picture, you can see how, yeah.
Okay. On the same page, 168, on the lower right-hand side, could you describe, is this looking at the fence from your property or from your neighbor's property?
That would be, that's what my neighbors would look, or, you know, or from the, yeah, or from the edge of our property. Yes, that would be the view from 211 towards our property.
And so would the new fence be on this side of your fence, between your
It
fence
would
and
be
the
among the
trees?
trees and our fence.
Okay. Going back to the image on the upper left-hand side of packet, page 168, from the left to the right-hand side of that photograph, which direction does water flow?
The water flows downhill towards what I can say.
Does it start here on the left?
On the left, you see some bricks. This is the tree. So the water passes by like 3-4 feet to the right of the tree towards west, and that's where it goes downhill. So it goes
Sorry, which picture are we
towards
talking about?
211,
168.
like how can I say, like, could be 20 feet or 15 feet from the corner with Trudy 4, and then it spreads. And it spreads down to the neighbor's yard and, you know, at our, you know, border there. I don't know. It used to have plants, but they died, and they were buried under silt.
And so if a fence were built on the other side of the fence that we see on page 168, the upper left, if a solid fence at ground level were built in that location, what would happen to the water that now flows from your property through your fence?
It would back up and then be forced towards the house. North is higher, west is higher, south is blocked. The only way is up and to the east.
Okay. If we could see exhibit number 14, please.
So,
Does exhibit 14 reflect flooding conditions in your backyard?
That was the first big flood that happened in our yard. Since then, it periodically happens. It's not an everyday occurrence, this amount of water, but it does happen. What happens every day is like the constant wet, and so there is constant water. That was a rain event occurrence.
And do you have any concerns about what would happen if a new fence would not allow existing rain runoff to flow off of your property?
It would definitely come towards the house. One, then it would increase seepage. It would increase lateral pressure to the basement walls. And then the water, in its effort to go and find a way out, it would try to pass among the 9.5 feet of our side yard to the east, which would create erosion. It would create problem with our foundation
Objection as to speculation.
because standing water and seepage do not only create mold, but also water in a clay, which is an expandable area, can create lateral pressures. It can also create an upward motion to the foundation of the building, meaning that it creates some negative pressure. Multiple expansion, clay goes in and out, and that creates movement to the building. And then it is also my understanding that this building was had the foundation being treated. I don't know how to say it. They didn't create a foundation on clay. They used other materials because clay is a material that is not good for foundation. So
Objection.
they had to create like a 3 pounds per inch capacity, load capacity. No?
What is your, could you tell the board what your professional background training is?
I'm a civil engineer, and I haven't practiced in US, but I have practiced in my native country, and I have done licensing and code. And I was licensing private buildings, and I have also done some public works.
And to be clear, we're not offering her as an expert, but I did want the board to understand why, the perspective that she has on the testimony that she's giving. Are you looking for your neighbors to any way improve the drainage situation that you have right now?
Oh, yeah. I mean, we told them we don't care what kind of fence they like to see, as long as they don't prevent the water from its natural flow. And in the past, we have discussed how can we work together to alleviate our water problem. So we were really surprised when we saw this fence, because otherwise we were considered to be friends.
I would like to bring a couple of statutory provisions to the attention of the board. In addition, of course, to the review standards under the zoning code, the city code section 24-165A8, which is in the record, says that structures, including fences, may be located with any front, side, or rear yard setback, and also within a building restriction setback, so long as the location of the structure does not interfere with the use of any abutting property. I may have misunderstood, but I thought during the preliminary motions arguments, there was a suggestion that we were objecting to the location of this fence in the setback. We are not. We are objecting to the location of a fence with a design that, if water is running downhill, creates a barrier that allows that water to back up onto the uphill property. That interferes with my client's use of her property. We're not looking to have the neighbor make the existing conditions better, in the sense that this is the flow of the water that exists on my client's property right now. What we do object to is making it worse. And it's our view that among other provisions, City Code Section 24-165A8 prohibits the construction of a fence if it would have that negative effect on an abutting property. And this would have a negative effect on the usability, and concerns are that it might ultimately result in structural damage to
This seems
to the
like
property.
argument as opposed to testimony.
Maybe I misunderstood the process. I am moving into argument. If that's-
Our rules of evidence and procedure are a little bit different than a typical judicial proceeding, so we'll accept.
If this is closing argument, I'm happy to reserve it for later. I believe I've concluded with my evidentiary presentation.
You can proceed within the timeframe and move on to an argument if you'd like.
Okay, thank you. In addition to that, the City Code 24-167-5 fences does say that the goal of the statute is to protect public health, general safety and general welfare, and increasing the flooding on an adjoining property's owner, on an adjoining property. Increased ponding, increased flooding does not protect the health, safety, or welfare of my clients. In addition to that, I'd also like to bring to your attention, this is Exhibit 5B, and this is the provision that talks about site development plans. And I heard the city argue that this does not apply. You do have in evidence confirmation that these properties are the subject of a site plan approval, and that is exhibit number 32. The last sentence of section 24-172 says, use and development of land which is the subject of the site development plan, or the construction of a building or structure thereon, in a manner not in compliance with that plan is prohibited and shall constitute a violation of this chapter being Chapter 24, the zoning code. The property is subject to a site plan. Structure in the city code is defined in the zoning ordinance, and that definition is anything constructed or erected with a fixed location on the ground or attached to something having a fixed location on the ground. Among other things, structures include buildings, mobile homes, walls, fences, billboards, and poster panels. So it is our position that it is not only the city code provision cited by the city that governs whether or not a fence can properly be approved in this case. The review and approval is not limited only to 24-167 of the city code, but these other several provisions that I have provided to the board all govern, they all work hand in glove, and section 24-172 in fact prohibits the approval of the fence unless the applicant comes in and seeks an amendment to the approved development site plan. That concludes our case in chief. Thank you.
Thank you. We'll proceed.
May I have a chance, brief cross-examination?
I forgot about that. Yes, you may.
All right. So, pull up, can we have Exhibit 4, please?
You might want to go to the podium.
All right. Ms. Tzioumi?
Tzioumi.
Okay. Just to be absolutely clear, your objection to the proposed fence is only to the portion that borders along your property, which is that 55-foot line, correct?
So
Can you just move forward to speak into the
mainly,
microphones?
yes.
The microphone's not going to pick you up.
Speak to the microphone, yes.
Okay, so mainly yes, but having said that, that 107 feet, I think this is the first application, not the second application. I think the second application is 98 feet or something, because there were like the 10 feet from the easement, they were subtracted. So, anyway, so according to the plats, there is also water coming from Trudy 4 that drains also, that comes towards 211. So,
But that doesn't concern your property, does it?
well, it does if it backs up in us, but I guess if our side is high, then it ends back into 11. So yeah, mainly the concern is our side. I've just wanted to note that
Okay.
it's not only our property that's higher level than from 211.
And so the only problem you have with the fence is that it could potentially aggravate the flooding that already occurs in your yard, correct?
Yes, and the reason is because those 10 inches, nobody will be able to mow. Nobody, if it's down to the
Well, I'm
ground.
just asking about the flooding, the aggravation of the flooding in your yard. That's,
Not agree.
She's trying to answer your question.
So we'll have vegetation that we won't be able to mow or weed whack. There is about 1 or 2 inches of silt per year that they are being flowing and deposited in certain areas and in this area. I have cleaned up when we bought the house, we had to clean this whole area. Our fence was almost falling at 211 because of all the
Ms. Tzioumi,
silt.
I'm asking a yes or no question.
So,
Let me re-ask the question. The only problem you have with this fence, with this portion of the fence, is that it could potentially aggravate the flooding that already occurs in your yard. Is that
that
correct?
it will aggravate the flooding, and it will create.
That is the only problem that you have with this fence, is that right?
Yes.
Okay. Can we go to page 137?
Do you have an exhibit number?
Exhibit number 14.
That's 137.
This is page 137. And if you
These pictures are the most recent time your yard flooded, is that correct?
This is, yes, from 2019.
Yeah, I was going to ask you about that. Some of the photos that you've submitted are date stamped, but these photos are not. Why is that?
Oh, because they were not turned on, like the camera, it was on and off. When I take a picture, I don't know if it writes the date or not.
Okay, so assuming that these pictures were taken in 2019, do you remember what month they were taken in?
No.
Okay. Is there any other recent photographs that you have other than these 2019 pictures of your yard flooding?
I do, but I haven't gone through them. I can admit I have fallen behind.
And you didn't think it would be a good idea to submit those into evidence for this hearing?
Well, I do have a few, but those were like, I have a lot of pictures, you have to understand, and it's hard. Those ones I had already checked out because I had already submitted them to the city once.
Can we go to Exhibit 39, please?
Yes, and I have some.
Looking at Exhibit 39, page 1, These photos are also not date stamped. Do you know when you took these pictures?
One moment. We don't have a hard copy of that one.
Okay, I can see. I don't know what date it is.
No? Okay.
I have
Is
to.
this,
Come to the podium so that you can see and speak into the microphone. We need you on the microphone.
come here,
Okay.
ma'am, if you could speak.
You need to speak
Yeah, I'm
into the
just trying
microphone.
to see. Okay, I cannot see the date, but those.
Speak into the microphone, ma'am.
Yes, I cannot see the dates.
Do you
I
know,
may have them,
do you remember when these pictures were taken?
no.
Okay. Is this what your yard looks like today?
Pretty much after, in the winter, when
Okay.
when the weeds that they are there, they die because there's no grass, that's how it looks.
Okay, and can you indicate where 211 Sportsman Way is in relation to these pictures?
Left.
To the left side. Now, looking at the top right picture, is that a wooden beam that's running through your yard?
Yes,
Okay, and how tall would you say that wooden beam is?
it's, I mean, the total would be about 8 inches.
8 inches? Okay, and did you install that?
Yes,
Okay, and then if we go to page 3 of the same exhibit.
Is that the one you want?
Yes, the bottom left picture, if you could zoom into that, if that's possible.
yeah.
You see that wooden beam, is the wooden beam in the middle of your yard the same as this beam that's shown here in that picture?
No, that's a 4x4.
Okay, and how tall would that be?
1.
One, okay, so in this picture, it's safe to estimate that the accumulation of water there is about an inch high. Is that accurate?
No,
You wouldn't say that?
no.
Okay.
I wouldn't say, I mean, I don't know, it depends.
And
It
the yard,
depends.
on the other side of your fence
I mean,
that's
here it's all mud.
right. On the other
And,
side,
yeah,
on the other side, that's 211 Sportsman Way of the fence, correct?
yeah, the other side of the fence.
Okay. And obviously, there's no fence currently there, correct?
Right now,
In
No,
the picture?
no.
Right. So, wouldn't it be safe to say that regardless of whether there is a fence in 211 Sportsman Way, you would continue to have flooding issues in that area of your yard?
flooding issues over there, it's gonna be,
Come closer to the microphone.
I mean, there is a situation going on there, but all this water that rushes out of our yard, can you imagine holding back all these cubic meters, how tall it would go? And then, like I said, it wouldn't stay there. It would just flow towards the front, okay, there's not here, and it would interfere with our south side of the house where our HVAC is,
Right.
where is our window that we want to create an up-to-code
But
egress.
you testified that in that picture, there was approximately an inch of water that had accumulated, correct?
No, I didn't say that. I said that it could be, it could be not.
Okay.
It depends on the time, if it flows, when it flows.
So depending on the time, there is or is, sometimes there's an inch of accumulation, sometimes there isn't.
There is no 1 inch in there. There is water running, and I have more pictures if you want to see.
I've seen them, ma'am.
No, I have more, even more. I just had
Since-
to pick a few pictures and put them
Since
here.
you've been residing at 209 Sportsman Way, has there been a fence in 211 Sportsman Way?
No,
Okay. And if we go to page 2 of that. The bottom left, if we could zoom into that. Okay. And then this is a picture from April 30th, 2014, that
Yes.
shows water accumulation in that same area, is that right?
Right.
Okay. And,
You can see the flow.
right, ma'am, so is it accurate to say that water has been accumulating in that area since at least April 30th, 2014?
Water is going through this area since probably before we bought the house. It would just had been fixed so we can buy it, because when we were to buy it, we didn't see those kind of things.
Okay, and if we could bring that picture up again, sorry.
Counsel, if I may, you said brief cross, I believe. We didn't
Okay.
time box it, so.
I just want to make one quick, my direct is not going to be long at all.
So I just want
Hold on,
also
hold on,
to
ma'am.
comment
Ma'am,
here.
I need to ask you a question. So your fence has 2 rows of pickets, is that right?
Yes,
Okay, and there's about 24 pickets between each post, is that right?
I don't know.
Uh,
I have never counted
Approximately.
them.
And then if we go to page 4, please.
You can see through.
Okay, and now, when were these pictures taken?
That was taken 2021, I think.
Okay. And that, you're standing in the backyard of 211 Sportsman Way, is that right?
I'm standing, yes.
Okay.
We because that day, a surveyor came.
It's just
and
a
put
yes
the
or no
stone-
question. It's
Yeah,
just a yes or no question. And each and every one of your fence pickets is embedded in the ground like the bottom picture shows, right? It's inside the ground, each one of your pickets.
it's
Yes or
not
no?
embedded, no.
Okay. Based on that picture, you say, no, it's not embedded. Have you looked into raising your own fence 6 inches off the ground?
It used to be.
Okay. And last question, on that left side picture, if you could zoom in, there's very little grass or vegetation that's growing by your fence. Isn't that right? It's mostly dirt, isn't that
My
right?
neighbor is mowing and weed whacking. I don't know
But
what
it's
else.
mostly dirt, wouldn't you say? Okay.
Seems like.
No further questions.
May I have just one moment, one question on redirect? Could we go back?
Can you
to-
speak to, they're just, we're
I'm
not going
sorry,
to have a record.
I asked if I could have one question on redirect, and if we could go back to the same picture on the bottom left, and I'm sorry, I don't know the page.
You looking for a different page?
No, the same picture with the water on the bottom left.
Okay,
It was
that's
the
right.
subject of so many questions.
It's up on the
Is
screen.
it 27?
If you can look at the screen.
Yes.
Okay.
So, did I understand you to say that the water on the bottom left was flowing through your fence?
Yes,
And what is your concern about what would happen with the water if a fence were built right behind the fence that you have now?
my concern is that it's gonna build up. It's gonna bring my fence down. And eventually it's gonna start moving towards the front, towards east, which is the only other way downhill. Yeah, and that will be problematic because it's a very small, it's only 9 feet among the building and the fence. And I think the total is about 9.5 feet. And if the amount of water in storm passes through, we're gonna have erosion. And like I said, it's gonna be bad for the foundation. It's gonna be problematic for the HVAC that is there, and for the window.
Thank you. I have no further.
Thank you. By our procedure, this allows questions from the board. So as we've seen, we don't operate like a true, judicial forum. We have sort of different rules, different procedures. So there's a chance for the board to present questions to the petitioner and counsel.
So you mentioned that there was 10 inches between where your fence is and where the other fence would be. So those 10 inches, whose property does that belong to?
That's another good question, because it's our fence is about 6 or 7 inches from the PL that we know of. We may be wrong.
And for the record, PL is?
Property line.
Thank you.
So, and then I think most installers, they back off 2 or 3 inches because anything installed on the property line is common property. So that would be a problem. So most people back off 2 or 3 inches to be. So I assume it would be about 10 inches. So we cannot mow this place. I mean, there have been like small. There has been small trees like grow. I mean, I have a Kentucky coffee tree, and sometimes shoots are going up there. And then should we take down our fence to clean up? Then it's gonna be our problem, except of the water. Who cleans up? Because then it's gonna be in our property. And then, as far as we're concerned, our fence is grandfather, and the burden of cleaning it shouldn't affect us. Because that was a fence with a permit that we found. And it's worked that long. We repair it, it stands still, so.
That's my only question for now.
Excuse me. Much of what you discussed talked about potential damage caused by the flooding that may occur in the future, getting stuck in your yard due to the new fence. I haven't seen anything yet other than in the packet a very grainy picture that it's very hard to see the bottom of the fence. That actually indicates that the fence will be flush with the ground. Do you have anything to present along those lines?
Can you please repeat?
I'm looking for information that shows that the proposed fence would be constructed flush to the ground.
Yes, our neighbor sent us a picture. I think it's here.
It is in the packet. I've seen the picture. That's the one thing that I've seen, and it's a very difficult to interpret picture to that level of detail. So I'm looking for additional information.
Well, I do have it's one in my phone. If actually there is another fence in the neighborhood, and everywhere. I googled everywhere, like Lowe's, Home Depot. Those fences are meant to be flush to the ground, and that's the aesthetics of this fence practically, and they are like for flat backyards, and even a small crack, like a small gap underneath, is just the height of the sod. If somebody lays like sod, then that's it. Then the gap underneath is being covered. So I was around the neighborhood, and if you allow me to show you how that fence, like the whole fence, looks.
So I don't know if it's necessary to introduce additional pictures about other fences into the record.
It's flush, it's just down to the ground. There is only one corner that I suppose it's 1 inch higher, and maybe through there they try to drain whatever they have. But then it's one house, and they control it. They can do whatever they want with it. So yeah, that house, if you would like to pass by and see it, would be like Pheasant Run at the entrance from Clopper Road. It would be Pheasant Run. Ooh, it would be like the 802 or something like that. Yeah, if you ever pass by and you see it, that's where it is. And I also noticed that this person who built the whole fence around their backyard, which is one house, they don't seem to have any other higher property significantly. They were siding with another property, I think it should be 804,
I would object.
which had another privacy fence exactly like ours, and they didn't put vinyl besides.
Thank you. Additional question I have is, we've talked a lot about potential damage caused by the potential flooding. And I'm curious if beyond the supposition that this could occur, and I did read the included material of dangers to homes. Thank you for including that in the packet. But in this specific instance, in the layout of this land, do you have any additional testimony or evidence that would increase the certainty that this type of damage would be caused by a fence backing additional water onto the property?
You're asking me?
I'm asking your counsel and you, yes.
And I would like to address that. There is obviously concern that there could be damage to some of the structural elements on the property. But the other piece of this that I think is much more pervasive is the fact that the code is concerned about affecting the usability of the property, your ability to use and enjoy the property. And so if you exacerbate the existing flooding, it means that you have more of the property that's underwater, adversely affecting vegetation or grass on the property. It means you have water that takes longer to drain. You have property that you have soils that take longer to dry in a manner where you can actually walk on them without it being just mud. So it's not just the structural concerns, it's the fact that, you know, if you exacerbate flooding that already exists, then you have created a situation where you have imposed an adverse impact on the property, and you have negatively impacted its usability.
Thank you. And one final question. In your written testimony, in the written packet, you included information about a couple Maryland cases. I wrote them down. Bishop and Richard and Biberman and Breckenhauser, I believe. Using those within our decision goes obviously beyond just what's within the Gaithersburg Code. So I'd like to give you an opportunity to speak briefly about how and why we should apply those.
Well, I think that it gives you a standard that you can apply in terms of when are you negatively impacting somebody else's property, when are you creating a burden, when are you having a negative impact on the usability of the property. The common law is clear. You can't increase the volume or the velocity or the speed of water on an adjoining properties. So I think it helps give you a standard that you can use to determine if there is a negative impact on the adjoining property. I know that there's an argument that this is just rainwater, rain falls, a fence can't affect that. I think that the testimony here makes it clear that the proposed fence does have or would have the impact of changing the speed and the velocity of runoff in a way that would, rather than accelerate it, would slow it down, but that change will have a negative impact on the uphill property because the water won't drain. So I see these cases really as establishing what the standard is for how you evaluate what's an adverse effect.
Thank you.
So to follow up on that point, I guess there's a difference between the affirmative, the language in one of the code sections is dumping, right? Versus, I guess what we're talking about here is damming and stopping up the drainage. So, can you help us understand then your sense of how the law applies there?
Yes.
When it's not the dumping from one property to another?
If you give me a moment so I can. Would you happen to be able to point me to the provision that you're referencing?
The point on dumping?
Yes.
Yeah,
I
that
think it's 24-165A8, is that right?
Just rattle it off the top.
I totally memorized that as opposed to writing it down
I believe-
in front of me.
I believe it's
Oh,
section
is it the
Section
20
813.
813.
813,
Yeah,
I
that's
apologize. Okay,
Exhibit
thank
5D.
you.
Yeah.
Because there's a couple of them that have similar language.
Yeah.
Well, it says, no persons shall dump, move, place, grade, excavate, fill, or by any action cause or permit soil, earth, sand, gravel, rock, stone, or other material, water or liquid to be deposited upon or to roll. So it's not just a question of, I'm thinking sort of like this earth moving. It's not limited just to that. It says by any action cause those things to happen. So I think it's read more broadly than just the words specific. The statute includes those specific activities that are identified, but then broadens it to other things that perhaps the drafter couldn't specifically identify here. It says, or by any action, cause or permit those things to happen. So, if it's a more it makes it clear that the statute should be read more expansively than just the specific activities listed in the beginning phrase.
And then the clause that you read, roll, flow, wash upon, or over the premises of another, your reading of that is that would include not coming from one property to another, but going on one property and staying on that property.
Right, because it says roll, flow, or wash upon, because if the water was going to flow out this way, but then if you backstop it and it flows back up to where it otherwise wouldn't reach because it's getting deeper, I mean, it's flowing in the opposite direction is basically what would happen. It's not sheet flowing across the property through the fence to the adjoining neighbor's property. It's flowing backwards and getting deeper.
Yeah. Okay. Okay. To that end, then can we go to Exhibit 33? Apologies in advance. We're going to be going back and forth, maybe once or twice.
What are we going? This one.
Yep. Okay. So just to be clear, on Exhibit 33, the wall of the fence that we were talking about in terms of creating damming on your property is the one that's in the top right of this picture, of this survey.
It would be to the right, on the other side of the red mark, of the red.
But that would be the location.
Mr. Chairman, perhaps I can have her mark on this exhibit, the section she's concerned about.
Sure.
And we can introduce it maybe as 33A. Can you?
We'll put it in as Exhibit
This is
45.
this is our fence here.
Okay.
So
you're
that would be
concerned.
the new fence. And
Okay.
that's, actually, this is how the water comes, this is 3.
Okay. All right. So just for the record, there's a blue line with some arrows along the side of the fence that's at issue. If I can show it to Mr. Pearl first.
Is it the same thing as, what's the difference?
He just asked her to identify what section of the fence she was
Oh,
concerned
okay. No objection.
Hold on. Yes, you can keep. We're not going to.
Thank you, okay. Where you wrote tree, that's a tree on your property line?
Yeah.
Okay.
yeah. It's
Inside your
also-
property line?
Yeah.
Oh, no, oh, yeah. I apologize.
It's fine,
It's a little bit higher, it's not there, but
yeah,
like,
understood, because we saw a picture where there was trees on the other side, so I was just trying to make sure I was locating that. Can we go to the next page, 185?
where,
Okay, so are you able to see this 185? This is the next page in the
Oh.
same exhibit. So this is where, what I believe you've done is you've drawn the direction of the flow based on the topography of the two properties. Is that
Yeah.
accurate?
yes.
Okay. And is there any significance to the really thick arrow that you've drawn in terms of quantifying anything, or is that just to make it clear that this is the area we're talking about?
Oh, yeah, that just wanted to be visible,
Okay.
it's us, you
Okay.
know.
So I'm going to ask a really stupid question that maybe none of us are experts on and can actually definitively answer. Do we know, first of all, that a fence to the ground, down to the ground with no clearance would create damming of water? I know that feels like an obvious thing to all of us, but do we know definitively that it's only going to be runoff, there isn't going to be seepage, there isn't going to be drainage elsewhere?
Though it's gonna dam, and the only way that the water can go is coming towards the house. Up until, depending on how strong the fences are, take both fences down.
Okay, and so it's your position that in this drawing, if we're looking at the big thick arrow that's pointed at the red border, that the water, if it does dam, is likely to essentially move to the left of the fence and to the front where that thinner arrow is drawn?
No, I put this arrow to indicate the isometrics,
Right.
the swales. Those swales are according to the plats.
Uh-huh.
And I just put it there like how the water should flow according to the plats and where the obstacle is. And then everybody can imagine what can happen.
Right.
Yeah.
So I guess my question then is if we're all imagining what is happening, and we have the topography as it's laid out here, if water is flowing in the direction of the thick arrow, no meaning to the thick arrow, just in the direction of it, and there is something created that dams it up, does the water then, if it's facing the fence, then move to the left between the fence and your house and then out towards Sportsman Way?
Yes.
Okay, that's what
Yes.
I was trying to understand. Thank you.
And thank you very much. That's a point that I wanted to make. If we see here this arrow, this swale does exist. And it's in this location because since we are on a slope, there has to be a certain distance and an approved inlet, which is a swale, from which the water can go through so safely among two houses. Now, we have a drop of 6 feet, and it's about 50, so we are on the, I think, over 30% inclination.
Mhm.
So the water according to IRC, it shouldn't be above the footing. Now, if the water goes among the building and the fence, then it's going to be flowing 2 feet over the footing, which is against the IRC provisions.
Got it. Thank you. I think this is my last question. Going back to the code, and I don't know if we've got a specific citation to move to just yet. If I have one, I'll let you know. It almost gets to the conversation we started this hearing with, which was the applicability of the permitting requirements versus the amendment requirements. And what I understand and will hear is that we're talking, basically there's a narrow definition, is it the fence? It's the permitting requirements. Is there a broader definition? It's the amendment in the site plan. Can you help us understand why the amendment in the site plan should apply and not the narrower requirements underneath the permitting process?
There is a provision in Chapter 24, Section 24-2, and it says the provisions of the chapter are declared minimum requirements. And it says whenever the requirements of this chapter are at variance with the requirements of any other lawfully adopted rules, the most restrictive or that imposing the higher standards shall govern. So the one of the basic principles of the zoning code is that you apply the more protective standard. Now, the site plan standard is in the zoning ordinance, but it says that if you're going to build a structure on a property that has a site plan approval, it needs to go through an amendment process or it's a violation of this chapter. And that makes a great deal of sense, and this particular case is kind of the poster child for why. And it's because when you look at the plats on Exhibit 36, which are here, and as you may know, when you approve a site plan, you approve the overall grading for the site, in part because you want to make sure that you're managing stormwater throughout the site in a comprehensive way. And so the exhibit that you were just looking at with the arrows, you can see the topo and you can see the grading, and as was explained, there are specific swales designed to direct the water from higher parts of the subdivision into lower sections and direct them to streets. And so to allow construction of a structure that would impede the original way that the entire project, the entire subdivision was designed to manage that, is exactly why you would want to see a site plan amendment before building a new structure, because it's a comprehensive design. So I think if not the letter, certainly the spirit of the provision that says that the more restrictive standards apply operates internally to the zoning code itself, as well as more generically to other parts of the city code.
Okay. One last question then. You're asking to reverse permit. You also said in the alternative, create 6 inches of clearance. Is there any authority that you can cite to where the city can require in the fence permitting process any influence on the design of the fence, which that essentially would get to?
I don't think I can provide that to you. I think what I could proffer is that if the fence owner were willing to accept that as a condition, then that would, we would withdraw the request that the permit be denied.
Understood. Thank you. Any further questions from the board? Okay, that means we are moving on to presentation by the city. As stated, 30 minutes with a 3-minute warning. And begin when you are ready.
Thank you. Eric Pearl on behalf of the City of Gaithersburg. Calling Sam Copeland. Mr. Copeland, can you please state your name and job title for the record?
Sam Copeland, Planner 1 for the City of Gaithersburg.
And how long have you worked with the city?
Over 2 years.
Okay, and as part of your job duties, are you responsible for reviewing and issuing fence permit applications?
Yes.
And as a planner who reviews and issues fencing permits, do you have experience and knowledge of the applicable fencing code regulations in the city?
Yes.
And approximately how many fence permits have you reviewed while working with the city?
50.
And
I'm sorry, could you clarify, was that 1-5 or 5-0?
5-0.
5-0.
Can you go over the process and procedure that you follow when you receive a fence permit application?
Yes, so we start to make sure it's a complete application. We then make sure it meets code standards. If it's a fence that requires additional reviews or notifications, then we forward as required.
Okay, and for this particular case, did the permit applicant submit all the required documentation?
Yes.
Can we show Exhibit 23, please? Are you familiar with fence permit application number 28847?
Yes.
Okay, and were you the primary city staff member who worked on this application?
Yes.
Okay, and what is the property address where the fence will be erected?
211 Sportsman Way.
Okay, and is the property considered a corner lot?
It is.
Okay, and what two streets border 211?
Sportsman Way and Trudy Way.
Okay, and when was this permit application filed by the permit applicants?
August 2nd, 2022.
And can you explain what the application requested?
Yeah, a new 6-foot tall vinyl fence.
Okay, can you elaborate on the specifications?
Yeah, it was a total length of 216 feet, height of 6 feet, vinyl fence.
Okay, and is the fence intended to be built right or within the permit applicant's property line?
Yes, 4 to 6 inches from the property lines and will not be built within easements.
Okay, and does the city code impose any restrictions with respect to the type of fence that a property owner can erect?
No.
Okay. Does the city code impose any mandatory regulations regarding the fence clearance above the ground?
It does not.
Okay. And does the city code impose restrictions with respect to the fence height?
Yes.
Okay, can we go to Exhibit 5A, please? All right, and Mr. Copeland, in your knowledge and experience, is this the section of the city code that deals with fencing regulations?
Yes.
And as a corner lot that borders other properties, a proposed fence on 211 Sportsman Way, which of the subsections of section 24167 would this proposed fence have to meet?
It'd meet all of them, but especially near the bottom, 4, 5, 6, 7.
Okay. Would it have to abide by subsection 3 regarding fences in front yards?
Yes.
Okay. And based on your review of the application, did you find that the permit application met the regulations of subsection 3?
Yes.
Okay. Subsection 3 restricts front yard fences to 3 feet. Is that correct?
By right, yes.
Okay. And in this case, what was the requested fence height?
6 foot tall.
Okay. And can you explain what the process is in order to construct a fence height that's taller than that which is required by subsection 3?
Yes, so it's a corner lot, so therefore 2 front yards. 6 foot tall fences can be approved in front yards, provided that they notify adjacent property owners where the fence abuts. The notifications were done correctly, the Department of Public Works was okay with the proposed location, and the applicant submitted a narrative of how the fence location would not cause a hazard.
Okay. And did the city find that this portion of the fence would be a hazard to vehicular pedestrian traffic?
That it would not be a hazard to vehicular traffic.
The city found that it would not be a hazard to vehicular pedestrian traffic.
Correct.
Okay. And who makes that determination?
That would be Department of Public Works and John Schlichting.
Okay, can we go to Exhibit 8, please? And is this the standard form the city requires permit applicants to deliver according to subsection 7?
Yes.
And when was this form submitted to the city?
Staff was notified on August 12th that the forms were given out on August 7th.
Okay. And can we go back to 5A, please? And then in reviewing the fence application, did you find that the permit application met the regulations of subsection 4 regarding fences situated on corner lots?
Yes.
Okay. And in reviewing the fence permit application, did you find that it met the regulations of subsection 5 regarding fences bordering properties?
Yes.
Okay. As written, do you believe that the fence permit application requests a fence that meets all the relevant requirements and regulations of the city code?
Yes.
And as written, do you believe that the fence permit application requests a fence that would violate any relevant provisions of the city code?
No.
Okay. No further questions.
Okay, thank you. Gives us a moment for, or a few moments, stop for a second, for questions from the board.
You go first.
I have a few questions about some of these sections in the code, starting with section 8. That was brought up, specifically section 813, but I'd like to back up and ask your opinion of the overall relevance of section 8 to this discussion.
Me or Mr. Copeland?
Either.
Either one? All right.
Someone at the green table.
You want to take it? All right, I'll take it. The purpose of section 813, which is, I believe, the section that is in question here.
Well, so 813 was the one specified, but the entirety of section 8 is really my question.
The purpose of this article is, it says, to protect and maintain the public health, safety, and general welfare by establishing minimum requirements and procedures to control the adverse impacts associated with land disturbances. A fence is not a land disturbance. A fence is a structure that, you know, any landowner has by right, so long as they abide by section 24167, the right to erect. The whole point of chapter 8, specifically, I believe, section 813, which is land disturbances caused by one property owner onto another, is to prohibit the dumping, moving, placing, or by any action causing, in this case, water to go roll upon or go onto the property of another. To interpret this section to include fences, I think, would be a misinterpretation of what Chapter 8 calls for. Just by the basic language of Section 813, the prohibitions that are put forth are to prohibit somebody from physically putting any sort of material onto another. To say that a fence would cause any sort of material, whether it be water, soil, whatever, to enter the property of another, that's not what's happening here. Water is entering onto her property. Water is causing to come onto her property by rainfall. What happens after that water is already on the property is not what is meant by Section 813. The water is already on the property. What happens with respect to the water after it enters onto our property caused by things outside of the property, that's not what Chapter 8 contemplates.
Thank you. In your review of the application, was there any indication that that other than digging holes for fence posts, that there would be any necessary grading, excavating, or other land disturbance?
No.
Thank you. Sorry, I have a lot of notes here. In respect to the Maryland case law that was discussed. Why do you feel that it is not relevant to our discussion here?
So the application of that civil law doctrine in Byerman versus Funkhauser, I believe is wholly inapplicable to this case, because a violation of that doctrine creates a private cause of action between property owners. That's not what we have here. That's not the issue that we're dealing with here. The issue that we're dealing with here is whether or not the city approval of the fence permit application was clearly erroneous and or legally invalid. A violation of that civil law doctrine is irrelevant as to answering that question, which is the main question that we have here today. Moreover, based on the pictures and the testimony on cross-examination, 209 Sportsman Way is currently and has for years suffered from inundation and flooding. And the whole point of the civil law doctrine is to prevent a lower landowner from causing water to accumulate onto another. You've seen evidence, you've seen pictures that water accumulation is occurring with or without a fence. So we don't even get to the level of analysis required by that civil law doctrine. So for two reasons. Number one, it doesn't answer the main question that we're here for today, which is whether or not the city's decision was clearly erroneous. And number two, this, based on all the evidence that you've seen, the accumulation of water is ongoing. It's been occurring since at least 2014, which is the earliest pictures that we have. So to say that this proposed fence would cause that accumulation is simply incorrect.
Thank you.
For Mr. Copeland, so you said you've approved 50 fences. In your experience, have you come across any situation like what's being alleged, that a fence causes a runoff?
No.
Okay. And is there any sort of precedent for this case, or is this in Gaithersburg?
Well, I don't think there is precedent, because I don't think that the whether or not a proposed fence would block water, it's not something that should be taken into account in the city's decision of whether to approve or deny a fence permit application. So no, there isn't precedent, because that's not something that the city should or does take into account.
Thank you.
Okay, so then let's talk about that then, because that gets to the question I have around permitting. If we go back to Exhibit 23. Whether with reference to the permit application or not, is permitting, you've used the phrase a number of times, by right. Is permitting for a fence, is it as simple as comply with the requirements in this checklist and it gets approved? Or are there situations where, whether it's Article 8 or otherwise, some other regulation, consideration is brought into play in approving or disapproving a permit?
Yeah, I can elaborate on that. So the application, if you scroll a little farther down, shows everything that's needed for a complete application. So the first thing we do is we double check that it's complete. So we have a digital copy of the house location, plat showing location, HOA letter if applicable, utility letters, like if they're putting it in the easement, which happens from time to time, an adjoining property owner notification form if applicable. Like I said before, corner lots have 2 front yards. So if they want to put a 6-foot tall fence in their second front yard along Shirley Way, that does require the notification form, so we require that. The next step is double check that it meets the code requirements. Once again, 24-167. We double check that the height is allowed, which is 6 foot tall. We check that it's not crossing property lines, which it isn't, because it met all the requirements. Planning was obligated to approve because it met the code requirements.
Okay, now that's another interesting phrase you just used, obligated to approve. So the second part of my question was, and I was told many times, just ask one question, not two. So the second part of my question was, has there been any situation where you've had a full and complete application for a fence, but some other consideration has led to the denial, especially because of some other rule or regulation?
Not in my experience.
Not in your experience, okay. Is there any authority for the Planning and Code Administration to place any requirements, design or otherwise, on the fence once the application is made and complies?
Do you mind rephrasing that?
Yeah, so I'll use the scenario. So, you know, the petitioner has requested a couple times, for example, if there's 6 inches of clearance, then we'd be okay with that. And, closed with that is essentially an offer, an olive branch, if you will, to the applicant. Are any conditions like that ever put into permits for fences in your experience?
No, there's no code section requiring clearance.
Okay, so private citizens, when they've created their fence, may have actually done that on their own, but there's no requirement that you would be able to put in terms of the permit.
Correct.
Okay. In page, okay, so your statement, which I forget the exhibit number, but this is like all the way at the end, or not. Where's the pre-hearing statement?
Exhibit 40, city's pre-hearing statement?
Yes, thank you. Page, if you go to page 5 of that. And if we go to the bottom, so a question for council. Understand there's debate about whether flooding and damming even matters. But you've dropped a note here that says the city maintains the proposed fence in the above captioned matter will not impede or prevent the natural flow of water from the petitioner's yard to that of the Mataranas, which is 211 to 209, or the other way around. You know what we're talking about. Can you help us understand that footnote?
Sure. So the footnote is with respect to the actual quote from the case where it says that Maryland, has adopted the civil law rule that a lower landowner cannot prevent the escape of water from the higher land onto his land. The whole point of this subsection, or this footnote 1, was that it, based on all of the facts that you have here and the facts that you don't have here, which is expert evidence as to whether or not this fence is going to be flush. I understand that the petitioner says it is. She's not, with all due respect, she's a civil engineer, but she's not an expert on fences. Her testimony cannot be taken at face value because she just doesn't have that knowledge. Based on all of the pictures that you've seen showing accumulation of water on her land, and the fact that we don't have any expert testimony or evidence showing that this fence is going to, as a matter of fact, be flush with the ground, and even if it is flush with the ground, impede water from going from 209 to 211. We don't even get to the Biberman versus Funkhauser analysis, because the Biberman versus Funkhauser analysis contemplates a situation where that has already happened. If you go through my explanation, in these cases, there's been a physical movement, excavation of land from one side of the property and creating a 3-foot embankment. That's not what's happening here. What's happening here is the erection of a fence, and again, we don't have expert testimony to say that with certainty that this fence is going to impede water from exiting 209 onto 211. So we don't even get to this civil law doctrine.
So would it then be fair to say, putting aside the civil law doctrine question, which is the point of the majority point, the major point of that footnote, that the claim in the first sentence of the footnote is as much speculation as the speculation that the fence would create damming?
Correct, but I don't have the burden of proof.
Understood.
Right.
I'm trying to understand if there was some evidence that was being offered that we weren't seeing or that hadn't been brought to the record.
Right.
Yep.
Right.
Understood. Okay. Can we go? And I think this is my last question. No, two more questions. Sorry. If we can go to the email correspondence. So Exhibit 6. And I know there's a lot of back and forth here, so we're looking for a specific page. Or the next one. Okay. One more, please. Previous page, sorry. I think it's the bottom of the previous page. Okay. Mr. Copeland, this is your correspondence at the bottom in red, right?
Correct.
Okay. You acknowledge that there were issues raised with damming and drainage. You said, as stated previously, because there's another email to the same effect, you can contact Greg Ryberg for any drainage issues that occur because of the new fence. What is the process, the remedy? What would happen were the petitioner to reach out to Greg and say, we have drainage issues because this fence has been erected?
Yeah, so I mean, once again, we're talking a lot about hypotheticals,
Sure.
hypothetical water. Sometimes if water does pool up, that could always happen, but it's a case-by-case situation. If it were to happen, we've offered the appellant several times to contact Greg Ryberg because he's able to go out there, offer solutions for any issues that would occur. Once again, we don't even know if they will occur.
Right. So speak specifically, not the hypothetical about what would happen if drainage were to occur, but when Greg is contacted because drainage issues are there, is it as simple as the process is he comes and inspects and provides advice? Is there support the city provides? Is there a process? Is there a whole other petition and appeal and filing that we have to go through if that happens?
I mean, once again, I've been here 2 years and haven't seen this happen, so I assume that he would continue what he's legally obligated to do to go find a solution.
Yeah. Okay. Last question for me, and this gets to apologies, everybody. Let's go to, I think it's 5, maybe it's 5A. Look at 5B. C. Okay. This is one of those places where there's the balance between, we're hearing here, it's the narrow application of the checklist to have a permit. And we're hearing here that there's a site development plan in place, and by the language of section 24-172A, sub B, a little bit further down, it mentions fences. A fence would be a minor amendment to a site development plan. So why are we saying that this would not apply and require and require a site plan amendment, which would then trigger, right, a stormwater plan and whatnot?
Yeah, I mean, it's always been staff's direction that any residential fence permit application goes through the fence permit process. This is traditionally used when you've got more commercial properties.
So I hear like traditionally used, but I'm trying to understand is like custom versus law, right? Is it supposed to be used in these circumstances also, and just traditionally is not?
All I can say is that fence permits are used without amending a final site plan for residential.
Okay. Any further questions from the board? I see a maybe.
Just have to look up one thing real fast. All right, yes, I have one more. Continuing on with the question about site plans and their requirement. Section 24168A of the code, number 2 specifies that the site plan requirement does not apply to single-family dwelling additions or alterations that do not add one or more stories, et cetera, et cetera.
What, I'm sorry, what exhibit are you on?
It's not an exhibit, it's in the city code, 24168A, number 2.
I can try to bring it up if you would like.
Please, thank you. I may be reading this wrong, and I'd like your opinions as your familiarity with city code, specifically zoning code. As to the applicability of this section to the discussion as to whether or not a site plan can be required based upon our existing code.
So my, if you can go to
Sorry.
37 or 38.
Hold on, I'm getting there. 24.
24168A2.
So site development plans, I'll call them SDPs. The purpose and like from the section 24168A, they concern the development of entire neighborhoods. If you go to 37, talking about the SDP that's being talked about in this case, if you go to exhibit 37 and 38, the site development, so this is 37.
Yeah.
This the site development plan is for the entirety of that neighborhood, right? And then on top of that, if you go to 36, this is another extension of, it's another phase and section of the same site development plan. The builder, like it says right there, is Pulte Home Corporation, right? So in amending or requesting an amendment for any site development plan, it's for the builder or developer to amend their own site development plan, right? Fence permits, in order to erect a fence, I think is a gross misinterpretation of when a site plan or an SDP should be used. That's the reason why we have 24167, because the erection of a fence is something that is by right, so long as you abide by 24167. Whether or not you have, in order to erect a fence, a homeowner wouldn't have to apply for a full amendment of this Pheasant Run site development plan because it entails the entirety of the neighborhood. Site development plans are meant to include large developments and aren't limited to small projects such as the one that's at issue in this case.
So which section of our code would specify that there would need to be a plan if I were to say, want to build a house on an existing lot in a neighborhood where the house burned down? I'm sure you would need a plan for that, right?
If the house burnt down,
You have a lot in a neighborhood, you want to build a new house, you want to put a new story on the house, something like that. Which section of our code would define when an actual plan is needed because of the scope of the development?
So that can be circumstantial. So it depends on if it was pre-existing, if they're going to rebuild exactly what was there before. You might be able to just go to a permit. It's not guaranteed that you have to go through a site plan or an amendment to the process.
Understood, but that conditionality is going to be defined somewhere. So where in the code is it defined?
Just by way of offering guidance, I'm not arguing one way or another, of course, but only guidance for you, that would be in the article of chapter 24 that does deal with site development plans, and actually the sections that you were talking about do lay out what are some exceptions. For example, just by way of background, it can be possible for a single-family home site to come in for a site development plan. They would look to the provisions of Article 5 to identify when, where, what is required, when can we do a permit, or when is, for instance, if you're going to add to a house, there have been instances where the Planning Commission does have to review that. There are minor amendments processes, but generally it's laid out in Article 5.
Excellent, thank you. So
If I can direct you I have 24-168 up on the screen. If you want to read the first paragraph of that explains when a site plan is required, and there's a reference to a use and occupancy permit being under circumstances which require the issuance of a use and occupancy permit.
So 24-168 is not limited to neighborhood level site plans, but could be relevant just to an individual lot site plan.
For the issue, well, I actually didn't read the whole thing, but it also which require the issuance of a building permit. So a fence wouldn't require a building permit.
Understood.
Right.
But this is the section.
Yes.
Thank you.
Yes, you would refer to this section in determining whether or not you needed a site plan.
All right, thank you. That's all.
Okay. That closes the presentations and creates an opportunity for testimony from the public. If there's anybody here who'd like to offer some, yes, you can approach the lectern here, and you'll be given 3 minutes with I want to make it a 30-second warning, but I don't know how to do that, so it's going to be a 1-minute warning. Could you, before we turn on the time, could you just tell us your name and your address?
My name's Fernando Matrona. I live at 211 Sportsman Way.
Thank you. And you may begin.
We just want to have a fence. The reason that we haven't done this in the past is that we now have a 6-year-old boy and we have a dog. Our dog's 2 years old. We were looking into this last year. We kind of stopped it. They said that we didn't like the fences that were there. There was a permit already submitted that stopped. We weren't ready to move forward at that point. They knew about it. They contacted us from overseas, concerned about a fence permit that we weren't ready to move forward with. Contacted them, talked to them last spring, said, hey, this is what we're planning on doing. Here's what we're trying to do. The reason we want it is we want to let our dog run around the backyard. And I want my son to be able to play soccer, play basketball in the backyard, and not worry about him chasing a ball onto the road. That's why I want the fence. Not building a retaining wall, as my contractor put it. It's a fence. Didn't really consider the water piece, but I don't want my fence damaged, spending a lot of money on it. I'm more than happy to raise it a reasonable amount. I said like an inch or two, but 6 inches doesn't work because then my dog can go under it, and then that defeats the purpose of it. That's it, thank you.
Thank you, appreciate it. Any other public testimony? Okay, perfect. That gives us an opportunity for rebuttal from the petitioner. You have 5 minutes
Rebuttal testimony?
for rebuttal testimony. Yep.
I'd like to go back to packet page 121. And this is the email from Mr. Copeland advising that if there's a drainage issue that we could contact Greg Ryberg for any drainage issues. And I understood his testimony to be that there would be a solution. With that background, have you contacted the city before about the drainage issues that you currently experience?
Yes, I have.
And what, explain what your experience has been.
Nothing was fixed. So as many times as I have called, nothing has been fixed. Now the water that you see in our yard, it's problematic, and it's not just a runoff. There are certain things that are going on, and they are visible. There has been water being redirected in our yard from neighboring properties. And I have called the city with pictures, with videos, with 813, and nothing has happened. So as you can understand, my trust is limited. I mean, I don't want to wait till it happens because I know what's going to happen. I've been calling the city for the past 8 years, and things are not happening. So, yeah.
I have no further rebuttal.
Thank you. Is there a motion to close the record?
I motion to.
Before we do that.
Yeah, do you need to, yeah, okay.
Go ahead, Frank. I'll
I
let
was
you
gonna
take
say,
it up.
you may want to formally accept the exhibits because until
That's
you
what I
do
thought I
that, that
was
hasn't
doing.
happened.
So the phrasing on that then?
There you go.
What- The two motions at the beginning, are they going to be included in the record is the other question.
I would say especially since they were discussed
heard.
and ruled upon, they should be.
Yeah.
I have no objection to them being included.
So we will assign them, the motion to dismiss will be 146, and then the motion in limine is 147.
Formal acceptance
Sorry,
of the record.
46 and 47, I don't know why I said 140. It just feels like that.
Generally, when because basically you're accepting and closing the record.
Yeah.
So, yes,
So
I
this
think
is-
the best way for the record, to reflect the full proceeding, I should say, would be a formal motion.
So what we're looking for is a motion to accept the record as supplemented and designated, and then officially close the record.
There you go.
Would one of you like to make that motion?
It could be so moved.
I motion to close the record and accept the other
additional
things discussed.
I second that motion.
All in favor?
Aye.
Aye.
Motion is closed, 3-0, which gives us opportunity for closing statements by each side. We will begin with, we'll begin with petitioner, 5 minutes. 5 minutes for closing statement.
Thank you very much. It's the legal arguments, the statutory provisions, and the evidence before you make it clear that this permit was issued in error as a matter of law. There was a fence application. The fence checklist, application, and review standards are one element of the city code, but the other element is contained in the site plan criteria. We had brought to your attention section 24-172, which says that use and development of land, which is the subject of the site development plan, or the construction of a building or structure in a manner not in compliance with that plan is prohibited and shall constitute a violation of this chapter. And I read into the record in full the fact that a fence is a structure. That is completely consistent with section 24-128, which says no structure shall be erected under circumstances which require the issuance of a building permit under this chapter until a site development plan for the land upon which such structure or use is to be erected has been approved by the City Planning Commission. You've heard information from the city attorney that there are minor amendment procedures that allow for a single lot to go through a site plan review process. So it is not inconsistent. What the fence review statute and the site plan requirements are not inconsistent. In fact, they are entirely consistent, as we had described earlier. A failure to require that would be incredibly prejudicial to my client. I know that there's been some discussion about the fact that there's no evidence in the record as to how close this fence will be to the ground. The evidence that you do have in this record of the fence is a photograph that was provided by the applicant that said, this is what the fence will look like. And if you look at that, you can see clearly that there is vegetation that extends above the bottom of the fence. By all appearances, it is flush with the ground. That is the evidence that you have in this case. We are not asking for the neighbor to make things better. We're asking them not to make them worse. First, do no harm. And with respect to the civil law that has been discussed here with respect to the flow of water and the drainage of water, it does not matter the manner in which the flow of water is changed. It can be changed because a gutter is redirected to another location. It can be changed because an underground pipe collects water and is daylighted somewhere. It can be changed because you modify the depth or direction of a particular swale. The concept under common law is that you can't change the volume, velocity, or direction of runoff. And that is precisely what the evidence in this record demonstrates, we say, by a preponderance of the evidence at least, that will happen when this solid vinyl fence is built just within inches of the existing fence. The testimony that you heard today is that the water flows under my client's fence. The testimony that you heard today is that it would then back up and flow onto her property. That's a violation of civil common law with respect to flooding. And it is a result, at least in part, of the fact that it is not being, the fence permit is not being reviewed and considered in conjunction with the drainage, the patterns that were established at the time this subdivision was established, specifically to make sure that water was funneled into these swales and directed off-site into the public drain system. We think that the permit was granted as an error of law. The question is that the law, or is it the custom? Just because it's has been done incorrectly time and again, doesn't mean that that makes it the law of the city. And it's our position that it is not. The permit was improperly issued on procedural grounds and should be denied. Thank you.
And I don't know what just happened. Let's screw that up. Let's try it again. For the city.
Thank you, board members, for your time here tonight. I want to start off by reminding the board of the burdens the petitioner carries pursuant to the Board of Appeals Rules of Procedure and Section 24189A of the City Code. First and foremost, the petitioner has the burden of proof to show that based on the record, the city's decision to approve fence permit number FENC 28847-2022 was clearly erroneous or not in accordance with the law. Secondly, the petitioner further shoulders the burden of persuasion on all questions of fact. Under Maryland law, the agency's action is presumed to be correct and may only be overturned if its actions was clearly erroneous based on the facts of this case. In order to meet this clearly erroneous standard, the board would have to find that there is absolutely no competent or material evidence to support the city's decision to approve the fence permit. And I repeat, there is no competent evidence to support the city's decision. Although the petitioner cited to various city code provisions throughout her presentation, the only code section that governs the approval or denial of fence permits is Section 24167 of the City Code, and that was directly testified to by Mr. Copeland, who has reviewed at least 50 fence permit applications. The petitioner's multitude of arguments regarding provisions found in other chapters of the City Code, including Chapter 8, Erosion and Sediment Control, and foundations, are irrelevant as to the city's review of fence permit applications and thus wholly inapplicable to this case. The board's decision of whether the city's approval of the fence permit was in accordance with the law should be solely based on the provisions of Section 24167, which expressly outline the procedural framework all city property owners must abide by when intending to erect a fence on their property. The testimony of Mr. Copeland is paramount. He testified that the permit application met all the relevant provisions in Section 24167. Furthermore, based on the permit application itself, it is factually evident that the proposed fence will be 6 feet in height throughout the entire perimeter of the yard. This meets all the criteria outlined in Section 24167. Based on Mr. Copeland's testimony, the provisions of Section 24167, as well as the proposed dimensions and specifications of the fence, it is evident that the city's decision to approve fence permit application 28847 was not clearly erroneous and was, in fact, in accord with 24167 of the City Code. The petitioner alternatively requests that the board mandate the proposed fence be raised 6 inches off the ground. However, the City Code does not impose any such requirement, and the board is therefore unable to legally impose such a conditional requirement on this permit application. There's no direct evidence in the record showing that the proposed fence would in fact impede the flow of water or be flush with the ground, on one hand, and on the other hand, there is circumstantial evidence based on all the pictures that you saw that the petitioner yard is currently suffering from long-term flooding based on the issues and aspects inherent to her own property and fence. The pictures speak for themselves. The water is accumulating at least 1 inch of water throughout years since at least 2014. The petitioner has provided pictures of flooding from April 2014, September 2018, December 2015, and if we take petitioner's word for it, 2019. These are rare and sporadic instances of flooding, and to take these instances as amounting to an interference with her use or enjoyment of the property would be incorrect. Her own fence pickets embedded into the ground are interfering with her use and enjoyment of the property, irrespective of whether a fence is currently placed on 211 Sportsman Way. Thus, her argument that Section 24165A8, saying that it will interfere with her use, is simply incorrect as well. As to the applicability of the SDP, Section 24168 specifically states that no site development plan shall be required to be submitted where the city manager or his designee finds that the proposed use is permitted within the zone in question. R90 is the zone in question. A fence is allowed to be erected within the R90 zone. So it's a use that's allowed within that zone. Further, that is substantially similar to the use which the premise was put by the last prior occupant thereof. The last prior occupant, as I stated in Exhibit 37, was the builder. The builder is the prior occupant of the land until those properties are distributed to private landowners. Therefore, the provisions of Section 24168 dealing with the applicability of site development plans is wholly inapplicable in this case.
Thank you.
May I respond in a minute?
It's not the procedure we had set forth. Is there an objection
I object.
to responding to your closing
To
statement?
rebuttal. To the petitioner rebutting.
If we allot you an extra minute, make it a minute each.
Okay.
I was just going to point out that under Section 24168, no site development plan is required when the use is the same as the prior use. It is required when you're talking about a structure. There's a difference between a use and a structure. Thank you.
No rebuttal.
Okay, thank you. I have legal questions. Probably worth us closing the floor. Should somebody else move that, or can I move that for that as the chair?
We can. Just in terms of your process,
Yep.
you're quasi judicial, but you are subject to the public hearing requirement that the case be heard.
Yep.
You did that with the closing arguments. That is the requirement that has to be in public, and I do the Open Meeting Act training, so that is what is in compliance. Now, in most cases for a special exception, again, those are zoning requirements. Those have to be completely upfront and in the public, even for the discussion. And administrative review, that is the quasi-judicial end of what you are doing. So it would actually be possible to end the meeting at this point, and the quasi-judicial part is to decide what to do from there. It wouldn't really require, you don't have to close the meeting for that purpose, because the quasi-judicial element of your work is not subject to an open meeting at all. So if you want to take that approach, you would simply close this meeting, and then you could simply reconvene in 5 minutes and discuss how you want to proceed with the order, questions, and discussion from there.
Right.
And that is this fairly standard for the other, there are other boards that also hold meetings that are subject to, and there are contested hearings, subject to the same process. And then there will be the quasi-judicial element that comes afterwards. So if you want to take that approach, I would suggest closing that simply ending this meeting at this particular point, and then we would be able to have our any questions you have for me, and decide how you want to proceed from here. And what would be clear is that any order issued would be provided to all the parties as soon as possible.
Okay, so you're suggesting close the meeting,
Mhm.
have our discussion, make a decision, and we would share that
Yeah,
decision.
I mean, you're not required to do that. The discussion can certainly be face-to-face, but the law does recognize that in a quasi-judicial matter, and particularly the number of issues, that it can be easier to simply try to lay out what you want to do, and that's where the Open Meetings Act does not require the whole process once you have satisfied the public hearing requirement.
Yep. You have an opinion? On closing the meeting, not on the.
Yeah, no,
But we'll really be ending this meeting and then
Yes.
Well, yeah,
finishing the part with the quasi-judicial discussion.
adjourning for a short
Yeah,
period of time
exactly.
for legal understanding. Um, I would prefer to have our discussion after that,
Right.
as part of the continued meeting.
Mhm.
Um,
Meeting take a few minutes now in closed session and come back.
Correct.
But our discussion leading up to a decision is not meant to be on the record like the way it is with a special exception.
But wouldn't that, you can close for legal advice, you do have to walk through the process to do that.
Yeah.
I believe we do have a member here who has gone through the certified training.
Yep.
Aaron, you did, okay. May want to get from, because I don't know that this was expected, if we have the checklist and all of
I have
that.
it.
But the main thing is to, that we'll, first of all, cite the Open Meetings Act provision that allows closing for legal advice. And then the reason for that is, I will say it and you can correct me if I'm wrong, so that our record says it. The reason for that would be to discuss the presentation and some of the legal issues related to the presentation heard tonight.
Yep.
And then with the intent to reconvene in a short time and make a final decision, or defer, or make whatever decision you're gonna make. And at the next open meeting, that'll have to be recorded, FYI. Do you need to have a motion, and you do need to vote in public to go into closed session? And I'm assuming we could go upstairs? Okay.
Yeah. I suspect that what we're trying to get is just some initial advice and consideration so that we can make a decision and make it fairly quickly.
Yeah.
Yeah. So, as the chair, can I make that motion?
I don't believe there's any limit in that at all.
Just being clear, because we usually ask for others. So, so I'll move that the Board of Appeals conduct a closed session this evening, whatever the date is,
11/9.
Wednesday, November 9th at 10:50 p.m. To be held pursuant to Section 10508A sub 7 of the State Government Article of the Annotated Code of Maryland for the purpose of receiving legal advice as just laid out by counsel. Is there a second?
Second.
All in favor?
Aye.
Aye.
Motion passes. We'll close the session. We expect to be back momentarily.
Yeah, actually, everybody can remain, and we'll, probably easiest for us to march upstairs. Would it be
You can stay with me tonight. You don't have to change when I'm around you. So go ahead and say what's on your mind, on your mind. When you and me, no judgment. You can get that from anyone else. You don't have to prove nothing. You can just be yourself. When you and me, no judgment. We can get that from everyone else, and we don't have to prove nothing. When you and me, no judgment. We don't have to prove nothing. When you and me, no judgment. I get us breakfast in the morning, or you can slip out in the night. You don't have to give me a warning, 'cause we both got nothing to hide, nothing to hide. Even though we don't talk for a couple of months, yeah, it's like we didn't lose any time. I could be a lover or your shoulder to cry on. You can be whoever you like. Oh, when you and me, no judgment. You can get that from anyone else. You don't have to prove nothing. You can just be yourself. When you and me, no judgment. We can get that from everyone else, and we don't have to prove nothing. When you and me, no judgment. We don't have to prove nothing. When you and me, no judgment. I hope we never change, even though we both know that we'll move on again. I'll keep your secret safe until the time we both find ourselves alone again. Oh, when you and me, no judgment. You can get that from everyone else. You don't have to prove nothing. You can just be yourself. When you and me, no judgment. We can get that from everyone else. We don't have to prove nothing. When you and me, no judgment. We don't have to prove nothing. When you and me, no judgment. We don't have to prove nothing. When you and me, no judgment.
You're giving me a million reasons to let you go. You're giving me a million reasons to quit the show. You're giving me a million reasons. Give me a million reasons. Giving me a million reasons. About a million reasons. If I had a highway, I would run for the hills. If you could find a dry way, I'd forever be still. But you're giving me a million reasons. Give me a million reasons. Giving me a million reasons. About a million reasons. I bow down to pray. I try to make the worst seem better. Lord, show me the way to cut through all this worn out leather. I've got 100 million reasons to walk away, but baby, I just need one good one to stay. Head stuck in a cycle, I look off and I stare. It's like that I've stopped breathing but completely aware. 'Cause you're giving me a million reasons. Give me a million reasons. Giving me a million reasons. About a million reasons. And if you say something that you might even mean, it's hard to even fathom which parts I should believe. 'Cause you're giving me a million reasons. Give me a million reasons. Giving me a million reasons. About a million reasons. I bow down to pray. I try to make the worst seem better. Lord, show me the way to cut through all this worn out leather. I've got 100 million reasons to walk away, but baby, I just need one good one to
there, Delilah, what's it like in New York City? I'm 1,000 miles away, but girl, tonight you look so pretty, yes you do. Times Square can shine as bright as you, I swear it's true. Hey there, Delilah, don't you worry about the distance, I'm right there. If you get lonely, give this song another listen. Close your eyes, listen to my voice, it's my disguise, I'm by your side. Oh, it's what you do to me, oh, it's what you do to me. Oh, it's what you do to me, oh, it's what you do to me, what you do to me. Hey there, Delilah, I know times are getting hard, but just believe me, girl, someday I'll pay the bills with this guitar. We'll have it good, we'll have the life we knew we would, my word is good. Hey there, Delilah, I've got so much left to say. If every simple song I wrote to you would take your breath away, I'd write it all. Even more in love with me you'd fall, we'd have it all. Oh, it's what you do to me, oh, it's what you do to me. Oh, it's what you do to me, oh, it's what you do to me. 1,000 miles seems pretty far, but they've got planes and trains and cars. I'd walk to you if I had no other way. Our friends would all make fun of us, and we'll just laugh along, because we know that none of them have felt this way. Delilah, I can promise you that by the time we get through, the world will never ever be the same, and you're to blame. Hey there, Delilah, you be good and don't you miss me. 2 more years and you'll be done with school, and I'll be making history like I do. You'll know it's all because of you. We can do whatever we want to. Hey there, Delilah, here's to you. This one's for you. Oh, it's what you do to me. 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 What you do to me. It don't bother me if you're old or young, if you got lots of money or you got next to none. Where you think we all go when we die? It ain't on my mind if you're big or small, how long it takes you to get up when you fall. If you can or cannot handle the spice, in a world where you can be anything, I'll be kind to you. Could you be kind to me? Kind to me is all I'm asking. La 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 la. Kind to me. ways in the room. If you get off the guys, girls, both none, or someone in between, or like to dress up even when it ain't Halloween. I don't mind, I say each to their own. In a world where you can be anything, I'll be kind to you. Could you be kind to me? Kind to me is all I'm asking. Yeah. See a few things differently. In a world where you can be anything, I'll be kind to you. Could you be kind to me? I don't want to die or fade away. I just want to be someone. I just want to be someone. Dive and disappear without a trace. I just want to be someone. Well, doesn't everyone? And if you feel the great dividing, I want to be the one you're guiding. 'Cause I believe that you can lead the way. I just want to be somebody to someone. Oh, I want to be somebody to someone. Oh, I never had nobody and no road home. I want to be somebody to someone. And if the sun starts setting, the sky goes cold, and if the clouds get heavy and start to fall, I really need somebody to call my own. I want to be somebody to someone. Someone to you. Someone to you. Someone to you. Someone to you. I don't even need to change the world. I'll make the moon shine just for your view. I'll make the starlight circle the room. And if you feel like night is falling, I wanna be the one you're calling. 'Cause I believe that you can lead the way. I just wanna be somebody to someone. Oh, I wanna be somebody to someone. Oh, I never had nobody and no road home. I wanna be somebody to someone. And if the sun starts setting, the sky goes cold, and if the clouds get heavy and start to fall, I really need somebody to call my own. I wanna be somebody to someone. Someone to you. Someone to you. Someone to you. Someone to you. The kingdom come, the rise, the fall, the kickstart. Me and my broken heart. I need a little loving tonight. Hold me so I'm not falling apart. A little, but I'm hoping it might kickstart. Me and my broken heart. Yeah. Shotgun aimed at my heart. You got one. Tear me apart and there's some. How do we call this love? Whoa, oh, oh. I try to run away, but your eyes tell me to stay. Oh, why do we call this love? Whoa, oh, oh. It seems like we've been losing control. what you made me do. I'm with somebody new. Ooh, baby, baby, I'm dancing with a stranger. I'm dancing, I'm dancing. Dancing with a stranger. I'm dancing with a stranger. Dancing with a stranger. Looking at it now, it all seems so simple. We were lying on your couch. I remember you took a Polaroid of us, then discovered.
A closed administrative session was held at 31 South Summit Avenue, Gaithersburg, Maryland, 20877 by the Board of Appeals on Wednesday, it's still Wednesday, November 9th, 2022, at approximately 10:50 p.m. Pursuant to a motion adopted unanimously. The session was closed pursuant to Section 3-305B7 of the General Provisions Article of the Annotated Code of Maryland to consult with counsel to obtain legal advice. The topic discussed was precisely that, legal advice regarding the issues at play, and then our own deliberation on the matter. Present at the session were board members David Belgard, Phil Cook, myself, Aaron Kotok. Staff present were Caroline Seiden, Jasmine Forbes, Jasmine or Jasmine?
Jasmine.
Jasmine, excuse me, and Frank Johnson. Upon conclusion of the discussion, the closed meeting was adjourned at approximately 11:25 p.m. So we are back, and thank you for your patience. We use this opportunity, as mentioned, for some legal counsel and for our own deliberations. With respect to that, we've reached a decision, and therefore I like to make a motion that the Board of Appeals deny administrative review BOA 93872022 and request staff to prepare a resolution of denial based on the findings and conclusion of the Board of Appeals. Therefore, issue a formal written decision soon. We'll talk a little bit about the timing. With respect to that, these are our basic core findings, which was that the main application among the code and regulations that we were looking at was primarily section 24-167, where we saw no violation shown by the petitioner. We found, with respect to section 24-165(5), that there was no interference in the ability to use the property, inconvenience perhaps, but not interference. With respect to section 24-16A, we found there's no requirement to perform a site plan for the construction of a fence. We found that sections 24-172 and 169 did not apply. That section 8, with respect to stormwater provisions, likewise did not apply. And I feel like I may be missing one or more of the considerations.
They denied everything we said.
Or did I catch them all?
Chair, I believe that the one other, and it may be capturing what you were saying, but piece of deliberation was that the thought that the water would substantially interfere with use of the property has to meet a strict definition of interfere, which essentially makes the property unusable to the owner, which we found did not apply.
Thank you. So that, at a high level, summarizes our key findings, which will be captured in detail in the formal written decision. And that concludes the motion. I don't know if there's any further comment from either of you with respect to the motion itself as detailed.
No, I'll second the motion as you spoke it.
All those in favor?
Aye.
Aye.
The motion passes 3-0, directing the denial of the administrative review. Caroline, Frank, can you address timing on the draft on the resolution?
So what I would propose is that we draft a resolution, since we have some very specific guidance from you on what should be in that. I think that we can distribute a draft individually to each of you for your approval. If there is substantial comment on that, we would have to reconvene at the next meeting to discuss. But if you are all in agreement that the draft is your opinion, in fact, and then we can have that signed and dated, hopefully within the next, I would say, week, hopefully less. Friday's a holiday, so that interferes with that. But I'll try to. We can do this by email with whatever guidance you provide.
Thank you. Is there a motion to adjourn?
I motion to adjourn.
I mean, we can stick around.
No, he's good.
If you want. Is there a second? All in favor?
Aye.
This Board of Appeals meeting is adjourned.